And isn't just as another argument to this discussion, isn't it that everything that we create is maybe or maybe not influenced by something from the past?
Especially nothing that is created from scratch, right?
Very, very few things today, I would argue,
are
completely
original.
We are mashing up two different fields and come up with a disruptive idea in the middle.
Yeah, and now every IPR lawyer out there will hate me for saying this, but I mean,
there are so many different related use cases. We have the the GitHub use case, the co-piloting, where we train it on the source code on GitHub, and then it can be used to help other developers to code.
Yeah.
They had the stable diffusion for image generation from text, that they are using Get Images or whatever kind of other data provider for images, and then training a model on that. I guess that's the same claim as Drake is doing, right? That they use training data that they don't have rights for training purposes.
Yeah.
What do we think about that? Is that
valid?
Yeah, exactly. Do you think that will hold up? I heard one decision recently. What was that? It was a Tesla car, right? The Tesla, was sued for an accident, and it was in self-driving mode, and they were freed, at least in that case. So even though the car went in self-driving mode and caused an accident, the company of Tesla was not liable for that, at least.
Because that court case boiled down to that it explicitly says you need to still have control of your car, and you need to be able to react. If you're not, so you're not, even if it can do and steer, you're supposed to react when something happens. That is explicit in all text on how to use.
In the terms and conditions that probably nobody reads.
Perhaps that's a bit different than using training data for rape.
But it's a very interesting conversation to have, I think, because I was pondering this myself the other day. What is the difference from just listening to music as a composer or as a songwriter and getting inspired?
Human, right?
Yeah. And then to sort of, in a way, download it into a machine sort of way. Because then we're already talking about a different sort of making. Then, I guess that's the part of the problem.
Is that the core legal problem? Is that if it's a difference between I get inspired in my soft brain, so to speak, and then with that inspiration I can make up some songs of that, versus the computer gets inspired by the data in the algorithm, wired, so to speak.
Not for copyright, but for patents, the difference is a significant difference, right? A significant departure, and that is this like weird qualitative thing that is very hard to measure and amounts to some sort of discretion. Is it the same with copyright? Do you know?
I'm not sure. No, I don't know.
Yeah. Because that, then it's not about the process, it's about the outcome.
Yes.
Shall I move this away, brother?
Perfect. No
okay. I thought it was a gentle hint to move it away from my mouth.
but still, what if we can just speculate about the outcome of this? I guess the Drake case, it's already settled because it was a takedown notice for Spotify and YouTube and everyone, so they've taken down the songs. I guess there will be some other court cases. There are some pending court cases for like GitHub, etc. They also have, I guess, a similar argument in that case that they use training data they haven't really been given rights to use.
Yeah.
And then the human comparison argument. I guess then in the future, or this will be fun to hear what you speculate. The difference will be. I think there will be a difference. As a human, you have certain rights to look at data, but perhaps machines will have different rights. And I think perhaps in the future it won't be possible to take the human argument to validate that the machine looks at data, and there will be different rights for a machine to look at data and for humans to look at data. Do you think that's the case, or what's your?
I think you had a great presentation last time about the machine being involved.
Yeah, so perhaps a parallel might be the willingness to attribute agency or ownership to an AI, which courts in the US and in Germany have not have declined, or at least not like main ownership of something, and so that goes then to agency. Is this algorithm capable of owning? Does it have agency? Can it make decisions? Which has implications. If you say that people do and machines do not, then there's the deliberateness.
Because humans obviously has agency. If a machine does not, it should have more rights. But wouldn't it the opposite result happen, that machines should have less rights, even though it has less agency?
Yeah. Or maybe it's to do with the fact that the machines can't explain how they got to where they are, right? It's there's no agency.
Can humans do that?
There's no.
But
they can attempt. They can draw metaphors. They can do parallels. It's imperfect.
A machine can also.
But if you
hallucinate.
but if you extrapolate on those cases, the case law, that humans can have agency, and we don't want, and machines cannot. I'm just saying that's what more or less what in Germany and US right now. That would mean that the legal framework around copyright and patents needs to be adjusted for how does it work when something has agency, humans, and how will this now work, or what is the implications when the machine doesn't have agency. I think it's a very valid entry point into contrasting that this goes down in two different types of laws, one with agency and one without. If you use, I'm just following that line of thought all the way through.
Yeah. So to just make it narrow, it's about ownership rather than agency, right? That they cannot have own intellectual property, AIs. And I'm suggesting that one interpretation might be about that is to do with agency.
And what is agency, if you explain it in layman's terms, and ownership?
So some sort of autonomous ability to make decisions, right?
Okay.
And are AI fully autonomous?
So the point of ownership is what we are debating, and then basically it derives down into, well, you can't have ownership if you don't have agency.
Yeah.
And then,
but that would mean that the machines can do more, but it does not. I mean, the opposite should be true, right?
No, I don't see how you can follow that logic. I only see that you can follow the logic that you need to have two different types of laws when you have underlying no ownership or agency and no agency.
Should you have less or should you have more rights when you have less agency?
I don't think you can do that principle that simple. I think you end up here you have something with agency and here you have something without agency. To extrapolate if it should lead in all cases that you have more or less rights, I don't think it's that simple. I think it's just two different strands of law.
I'm going to introduce a different perspective as well. When it comes to IPR, intellectual property rights, why do we have them? I think that's a good way to start, because now we're talking about the new the new composer and not the original one. But what are we trying to protect when it comes to the original composer or so on? So maybe
the origin argument of the law, why this law exists.
Yeah, right. Maybe starting there and not going forward to talk. I mean, I think the agency question is very relevant, but I think it needs to stem from what are we trying to protect? Why is it even there?
Good point.
Right?
Very good point. But what are we trying to protect? That's a good question.
Yeah,
right?
and
that's
so maybe let's
right?
start. Let's start there. Why do we have
originality, or what are we trying to protect?
Yeah.
Is it not in this context? It feels more and more like it's some sort of privileged position that humans hold, that others, including animals and algorithms, do not. Maybe cannot. I'm not sure, but
I would argue for economical purposes as well.
They're pragmatic.
Originally,
and also in order to enhance. Sorry, Henrik. In order to enhance innovation, right? Because if there are no gains, there are no incentives for you to ever come up with something new or original. Why would you ever do that?
Yeah, and
Right.
that applies in the pure human context.
Yes, exactly. That applies to human.
There's a second side to it, though. So on the one hand, so if you look at patents in particular, part of it is you can patent it so that you have a reward for the efforts of having done the innovation work to get the patent. But the other side of it is it creates an openness. Patenting, you then show how you got there, so that once your patent expires, it is available to everybody else. And so it's not just to encourage innovation by the person owning the patent or people who will then patent their work, but then after the fact for it to be open to everybody.
I will add a topic
I
about
love
speaking
that.
about patents, actually. The pros and cons of patents. That would be an awesome topic to speak about.
Patent was open source.
Yeah.
But this
Sounds
is,
like a rabbit
but
hole.
it's really interesting then, because I mean, like it's there for a reason, and I think it has to do with putting in the effort. It needs to be worth putting in the effort in some way. If you take it to the extreme use case, you can talk about the cost of developing medicine, right? It's huge cost. So you need to protect the people who put in billions to get it through the door. And as an extreme example, but I think that puts the point on patents and and all this. But the challenge then is, in my opinion, where does this lead to when it's not only humans and humans' economical value that we are protecting here? It's human effort, human economical value we are protecting. But how does this translate now with machines?
And also where the effort is not as large. Right, because the computational capacity of the machine is so much larger.
But someone needs to basically put the effort in to make the algorithm. Someone needs to pay for the electricity bill and the storage bill of the large language model. I don't know. But I can't answer this. But
we moved away from the original topic, I think. And now speaking about patents, and I have that in the list, so we can go back there. I think later it would be fun to just think about the pros and cons with that.
You're right.
But going back to the original question, which I think is really interesting with the Drake and the Weeknd song that was AI generated and taken down. Now really hard to find. It would be fun to listen to it because it.
Did you find it?
I did. It sounded
did.
really good, but it's hard to find it now. So otherwise, it would be fun to.
It was probably taken down immediately after you heard it because it's like this whack-a-mole game.
Yeah, but it took some time before they took it down, actually.
Yeah.
But can we find it now?
But still, if we just give some
Or
background.
then this episode will be taken down.
Yes, that's
Okay.
a high risk for that.
Yes, let's do it. Let me know.
No, but just to give some background, I don't recall exactly. I think it was some user on Twitter or something that claimed to have what was his name again? It was something with I don't recall exactly. Ghostwriter something it was called.
Yeah, the account that publishes.
And then he claimed, he created the song. He claimed it to be a Drake song, and then he published it. He earned a lot of money from it. And then later Drake, were upset about this, or the record label were upset about this, and they forced a takedown of it. And when I listened to it, it sounded really good, I must say. Better than usual. I'm not a Drake fan, so I shouldn't say that.
But now you became one after listening to that.
After the AI generated one.
Yeah, so maybe there is actually some benefit for Drake in that after all.
Or AI from that.
Yeah.
But that taste is different for every person, so that's fine. But still, in this case, if we speak about the originality that we spoke about, copyright laws, in this case, it was a completely different melody. It was a completely different lyrics.
I think this is the one.
It's quite convincing.
I know, but this is what this is the what is called a commentary.
Yeah, exactly. Those are the only ones that haven't been taken down, I think.
Yeah.
But still, and then we said in the beginning, okay, it's not the actual melody, like Ed Sheeran versus Marvin Gaye. It's rather the training data that they potentially used. We don't know what training data I guess they used, but still.
But it must have been training data based on Drake, in which case it belonged to Universal, or at least they own the copyright.
Yeah, probably. Yeah, I mean, it's a high chance for that, for sure. And then I guess that's the case. Are you allowed to train something and publish a song like this that is using training data that you don't have the rights to train a model on, right?
Yeah.
Or under what circumstances can you use and reproduce copyrighted data? And there is this provision for fair use.
Yeah.
Which you have more of a sense of than I do, the requirements for that, for fair use of copyrighted data?
Not actually.
But unfortunately, also have a lot of legal.
But we can do the
experience,
snillen spekulera in Swedish thing.
Philosophical hour here.
Yeah.
But I guess the term derived work is something that we could use here, right?
Yeah.
Is it derived work from some kind of original data when you use training data to train up a model and then produce something? If that's the case, then I guess patent, for example, should hold. If that were the case, or if you have copyrights on the training data, right? Would that be a fair way to say it? That if it can be defined that it is clearly derived work?
So my understanding is that derived work, which belongs to patent, is a different thing to copyright intellectual property, where there is space for fair use. So for instance, satire or parody, where I pretend to be Donald Trump. I even do his whole speech. That is fair use because I do it satirically, right? It can be identical, but there is an implied satire that comes from the context, and that's something completely different to a derived work, because there isn't like if you were to read a transcript of it, it's not necessarily different. It's identical, whereas derived work would imply that it is significantly different. So in copyright there is a kind of contextual difference for fair use. that doesn't exist in derivative work for patents.
But in this case, I guess you can't claim fair use because it was.
I think they are, or at least they could. There's a suggestion that they might be able to claim it, and then they end up in this difficult situation where, on the one hand, they're dependent on the kind of goodwill of music labels because they need their content on YouTube, but they also want to continue to support their AI, and if they can't learn from those data, from the music label data, then the dominoes all come down.
I think this is so interesting, and I have a topic later to speak more about the other similar use cases or court cases even with GitHub. Someone training on the source data of GitHub without having rights for that, and then training Copilot that helps so many people today, and Stability AI for training on other copyrighted images, and then being able to generate images by using that as training data. And is this correct? And how can this be resolved in the future? That I think would be a really interesting topic to dive more into, right?
Yeah, maybe we should take it later, but I think one core question that comes up as well: are we seeing any case law emerging here? Are we seeing like the way to interpret the world, and is this the type of law that we can sort of frame up front, or is it more case law emerging from how we have ruled in different cases? How what my understanding is a little bit different. If I go to America, the legal system is is built around case law, right?
Exactly.
Versus in Sweden it's civil law, right?
Law. You're common law.
Yeah.
lawyer, right?
Okay.
Me in South Africa, hybrid,
right? And so okay, so let's frame it now. You can set it up better than I can. Are we solving this civil law or case law? Is what is the feasible way to get our heads around it? And maybe you can define the difference for someone who doesn't. I don't even know what I'm talking about, as you can hear.
So the difference in a purely civil system is that all laws come from politically elected governments, from parliaments, and they are defined in an incredibly large amount of detail
in civil law, in a book.
Law, in a book. So you have criminal, enormous books of criminal law, and then what courts do is interpret in line with that and in line with intentions, but they don't create new law as such. In common law systems, courts are considered to be the same as a parliament, which is to say that you both have laws that come from parliament and then courts, particularly the higher courts, can create new law when the existing law is seen as lacking, or economic conditions, societal conditions have changed. In practice, it becomes a bit fuzzy, right? Because most legal systems have some combination. Because where is the line between interpretation and new law? So it sounds binary.
When I say case law, it's basically
common law. Yeah.
It's common law, and it's based
mostly,
on
but I mean,
cases, rulings in cases.
And it requires also an appellant. It requires somebody, a plaintiff rather, somebody who has a case that is relevant, who brings it up, right? In the absence of that, there's just a legal vacuum. Whereas parliaments can act preemptively. So
how did we end up in that topic?
No, I mean, maybe this is deeper, but I think that there's some sort of, if we want to understand how to solve this and work with these topics, I think we need to understand how to use the legal system, and we are most likely ending up in a hybrid, because you cannot imagine all the different variations of this because it's so new to us. So the cases will put.
But I don't think there is a lot of room for forum shopping. It depends on where the questions arise, and the ones that we're talking about, those are US based.
Yeah.
So,
but I think there's certainly an inclination both here in Europe and in the US to create guidelines. So in the EU, of course, it's the AI Act, which is being discussed very slowly. But in the US, they have this non-binding AI Bill of Rights, right? And so it doesn't have the force of law, but it starts to become persuasive, particularly in a common law system, where you can use it as grounds for argument, as persuasive rather than decisive.
Those grounds, persuasive, with the common law system turns into cases, and then the next case after that will claim from another case.
Yes, exactly. But those persuasive grounds come, or at least the AI Bill of Rights, then comes from a government, right?
Yes.
It's not or not a government, but policymakers.
So in a sense, hybrid.
And it's also my understanding that in the US there are more sector-specific acts of various sorts, and but we might go into the AI Act discussion later.
I can feel that this discussion will go on far too long, and it's one of the longest introductions we had, and it's high time to introduce the guests. And the topic, of course, as you can hear, is partly law, legal regulations, but also, I think, AI ethics in general in some sense. And we're also celebrating the 100th anniversary of the AI After Work podcast, so we're especially honored to have such two distinguished guests here today. So with that, it's awesome to have you here. And let's start with perhaps you, Jannika. And it would be fun to just hear shortly about your background. You're a professor, right, in information system?
Wrong way around.
Oh, sorry.
The wrong way around.
Sorry.
I was like, that's not me. Yeah.
Sorry.
You could be. Would you like to change tracks?
Let's discuss that afterwards. But first of all, big congrats to the 100th episode. Did you still want to introduce me?
Please,
with my correct? Sorry.
With an apologies for mixing you two up. I haven't met you before. I think I met you, Claire, shortly, but I haven't met you before. But with that, Claire, you're a senior legal...
Claire is there.
Yes. Oh, this is not going well.
But we can start with Claire as well.
Relax, have another beer.
Jannika, you're a senior legal counsel, right, in Knowit, and you basically are certified professional.
Yeah.
You have the, what was it, the SIP-E kind of certification, right? Certified information privacy, what was it? Privacy professional?
Yes, in Europe.
Yeah, in Europe. So that's specializing in GDPR and these kind of laws. So awesome to have such an expert here. We are speaking so often
all of these certifications.
About these topics, but we've seldom had experts.
Someone certified to talk about it in reality.
So it's great to have you here. But perhaps you can give a quick background.
Yes, absolutely. Happy to.
Who is Jannika Törnqvist?
Who am I?
I got that name right this time.
That is the hardest question we will be pondering today. No.
Yes.
Well, I am a Swedish-speaking Finn. Which means for anyone listening who doesn't know, that my mother tongue is Swedish, although I'm born and raised in Finland.
Yeah.
I come from Helsinki. I was born in Helsinki and raised just outside. And when I was 13, I decided that I will become a lawyer, for reasons that are blurry now. but
So nothing special that happened that made you interested in?
I guess I was always interested in how things work and in society and why is it that way, and that doesn't make any sense. But there is something called the law that says.
I was going to crack a joke. Come on, don't. We talked about this when you make a good story afterwards. You were just looking at LA law, like one of the
it was Legally Blonde. It was Legally Blonde.
Oh,
Legally Blonde.
Ally
Of course.
McBeal.
Yeah.
I think I was a bit too young. Anyways, yeah.
Okay, sorry. That was bad for me. I revealed my age.
But I mean, it was true. So yeah, and then I became a lawyer. Started in Helsinki, and when I finished my studies, I moved to Stockholm, and I've been living here for 7.5 years. I am working in data protection, GDPR, for various customers, various field sectors, and mostly as data protection officer.
Right.
So I am the.
So can you just briefly describe what does a data protection officer do?
Yes, I'm the great person that will tell the organizations what to do and not to do, and ask some very uncomfortable questions. Mm-hmm. But it's about monitoring and data protection practices in organizations, raising awareness, being involved in various data protection impact assessments of different kinds. And
I'm jumping a gun here a bit, but because I think it's interesting how lawyers can interact with companies and building systems in general in the future. I guess the DPO in this case is a bit coming from the outside, reviewing, giving comments about this is good, this is bad.
Or it could be coming from the inside as well. Many companies have their in-house DPOs.
Yeah, in-house in terms
as well.
It's a person.
But you coming sort of like.
It's not really in a development team.
No,
so, this is really
you're not operational, as we say.
Yes.
More, yeah.
Do you think? I think actually that could be a good upcoming way to collaborate in the future. I mean, normally you have a development team. They have these kind of cross-functional, skills in being a front-end developer, a database expert, an AI expert, or whatnot. Don't you think there should be need from the beginning to have a person that is more knowledgeable in fields of law, also during the development? Or
the DPO role or the one?
I mean, DPO. If you take your experience, the way you have operated as a DPO in the past. Let's say, I think it was some bank or something you worked in, right?
Yes.
And also, Klarna and etc. Yes. And if they were to develop some new system or change some existing system, and the question is more, when do you come in? Do you come in late in the process and say, okay, you have done this is good, this is bad, or are you part of the process early on?
Oh, right? It's a very good question. As ideally, the role of the DPO is more of a monitoring, reviewing kind of role. So not operational as in saying exactly how things should be done in a specific case, but more providing advice if necessary, and then monitoring more afterwards. So in a fully functional data protection organization, ideally the ones who are actually working with, say, vendor management or something like that, they are the ones who actually know how to also ask the correct questions of any vendor, supplier, etc. Yes. So ideally, but it happens that I'm
because
part of that.
I have a saying that is not very perhaps politically correct, but in my view, you shouldn't ask a lawyer if something is okay. You should ask a lawyer, how do we make this work? No,
but it's true. I really like this way of dealing with things and what is the problem we're trying to solve, because that really opens up a better communication. Instead of, hey, we have the flow is already done here. We just need to have a sign off from legal, which is very
and that's
classical.
Good.
Yeah, because when data protection lawyers or lawyers in general actually coming late in the process, we're not able to say like, hey, you could have, for instance, when it comes to transparency. What if we provide this information here, and then later in the flow we provide it here? But now in the way that you set up everything, and you just need to say no. Something.
I have to say no because the way you set it up.
Yeah, or maybe we just put everything in one place, and then it becomes not ideal and very ugly, and it messes up the whole thing, right?
But that indicates that the DPO officer that's working on advisory and monitoring and in quotation marks comes in late.
Yeah,
there is something else going on here, because to understand this in a good way impacts the design in a very, very early stage. Yeah. That's what you're saying, right?
Yeah. And there are also data protection lawyers or privacy officers or what do you call them in organizations who are more operational, who are there to help the organization with making these adjustments.
So now we're starting to look at the DPO and that sort of looks at what's our practice here, and then how do you operationalize this, and how do you make this discipline be part of the development team competences?
Except because what happens is that everybody thinks that the DPO will come in and save everything, because the DPO is the one who does data protection at the company, and that's not really true. Like, the DPO is actually only the one who is supposed to come in very late and just check that everything is working, and also give advice on how things could be done differently, and raise awareness and these sort of things. But these things should be part of the organizations already, meaning that there should be other stakeholders who are taking part in.
And who have legal knowledge, presumably, right?
Yes.
I mean, legal knowledge is not the exclusive domain of lawyers.
Exactly.
Just like technical knowledge is not the exclusive domain of software developers.
Absolutely.
And to make some of these decisions, you need lawyers who understand software. Otherwise, they don't understand what they're looking at. And you need software developers or other roles who also have some sense of the laws that apply, or the rules that apply, so that they can evaluate and do this kind of balanced judgment that you're saying often when someone like you comes in, it's too late.
But this is so obvious. This is so obvious to us sitting in this room discussing this with some experience of both good and bad ways of working around this. Is this obvious to the normal company? I mean, because I think the DPO role, the way you're framing it now, I think it is part of the legal structure that came with GDPR, that we need to have a so by law there needs to be this function, right?
Yeah.
And then we are looking at this from a pure legal perspective. We need to have a DPO. The DPO is here to really monitor and control and see that we're not doing right, but to implement that in your operating model, in your operations, means, of course, someone in the design phase needs to consider these dimensions.
Yeah.
And question mark, is this lost, or how many has really understood how far to take these roles seriously in the dev team, so to speak?
I think there are two pieces to this. The one is, where is the role of lawyers, and the other is, where is the role of IT? And IT so often exists, in the back office. You hide the software developers. Nobody wants to see them in their hoodies, and so it's a bit of both, right? Like where strategic decisions are being made that affect digitalization, you need to have people who have deep knowledge of the technologies there, and often decisions are made which are then passed to IT to implement, right? And so there's a siloing there that goes that way, but there is also then a siloing the other way, precisely because IT get often decisions or specifications that they have to then interpret, that they sort of left on their own, because the expectation is that somebody else has considered these things. And it would absolutely make sense. And organizations are moving that way, right? To have CIOs who don't just have technical education, they have other kinds of education as well, like legal education, who are then involved. So I think it's a kind of legacy problem, right? Like it has long been this way, and organizations are changing it in incredibly glacial way that they do.
And I think it's similar to if you take AI experts or data scientists, for example. I mean, traditionally, or in some other companies, they start to build up some separate kind of data science team in some way, and then they have the engineers in some other team, and that's a horrible practice, I would argue, at least. And I guess you can argue the similarity for lawyers as well. I think you need some kind of central hub of these people to still work, but to have at least a close collaboration or them being part of the development process or design process early on is crucial, right?
So at least that discipline is covered in the dev team in some way. As you said, we can have we can be T-shaped. We can have you can have a developer who has specialized as his second competence to be really good at the legal stuff, as an example.
Yeah.
Yeah, and one article in the GDPR actually specifies this specifically, and that is the privacy by design and default thing, right? And I think that is something that not always, but often goes missing, because there are so many other things that we need to have this in place, and we need to update our policies, and we need to have the records of processing activities, the ROPA in place, and everybody needs to be involved in that, and it's a lot of like manual work, etc., etc. So then this part, when it comes to like really embedding it in how we develop things and how like in process, who is doing what, etc., that sort of has gotten a bit lost. But what we can also see now is that there is a kind of second wave of GDPR. It's 5 years since that day, 25th of May.
So privacy by design, privacy, going in and thinking about these topics from the very get-go.
Exactly. And also in the design phase, because there are different moments or momentums where specific details should be in place, or there are different aspects to consider. So like not something that is brought up in the beginning, like I say, check, yes, it's done, but more like, have we actually considered this? And are we minimizing the amount of data that we're actually collecting? Can we argue why we actually need to know the nationality of somebody, or why do we need this and why do we need that, and then having it, maybe not everybody in the company should have access to this, maybe we should put on some limitations. Actually it's not encrypted in a, considering it that we have sensitive personal data, we should look to
exactly.
You said a second wave. What do you mean? Is there a new upcoming amendment to the GDPR Act?
No, more in the way that that companies are seeing that it's important, and actually seeing, because I don't know if you remember the panic that existed 5 years ago of like, okay, what will happen? Everybody will get fined, and so on. So certain things were put in place, but I think, generally speaking, this is not true for all, generally speaking, governing what was done then and making that part of your organization has not always been a priority. So some of that is now outdated and needs to be more, because we can see that EMU and other DPAs, data supervisory authorities, are active, and there are repercussions.
And perhaps you are seeing something similar with upcoming AI Act as well, who knows. But let's not go there yet, right?
Let's go to Claire.
Yes.
And perhaps also, you're now working at Knowit, right?
I'm now working at Knowit.
So can you just briefly, what do you work with at Knowit, and what is Knowit?
Yes. So Knowit is a consultancy firm specified in building a sustainable, humane society, with emphasis on digitalization and sustainability. So consultants, I'm working as a consultant. We are, I think, 4,400 in the Nordic countries and in Poland and Germany. And working in various ways.
So you help a lot of companies and have a lot of insight in how different companies now are trying to comply with.
And which is really great with Knowit, I need to say. As a lawyer, I have been very used to working with other lawyers. We are around like 20, 25 plus lawyers there. So we are a very small group among many other competences, and I think that's amazing because then you get a lot of input. For instance, when I don't know if you have been following the discussions of Google Analytics and so on, but then there is the marketing people that you can actually discuss with. Hey, what are the options? How does it work? Can we discuss this together?
I missed the Google Analytics thing. Is they getting sued in some way, or what's the discussion about Google Analytics?
So various, it's
the
a
AI
rabbit
Markets
hole.
Act and AI Services Act. Is it that? No.
So it's about
Sorry, the Digital Markets Act, Digital Services Act, not AI. Yeah? No. Okay. Never mind. We won't go down that rabbit hole.
It is a rabbit hole.
Okay, very briefly then.
Very briefly. So Google Analytics, I think it was version 3, if I remember correctly, has been deemed unlawful by various supervisory authorities in Europe. Oh. And there are a lot of things written about this. And Google has since then released other versions, and now it's a discussion about what is.
And do you know, is it something specifically in version 3 that made it unlawful, or?
It was again the discussion about third country transfers and sharing personal data
over to the States, or? Over
to the States. Also, because Google argued that they only recognize IP address, I think, as personal data, but there are a lot of other identifiers collected, so they actually know a lot about the users of this.
Interesting.
And so on. It's a
so many interesting topics here, I think. But before we go into more rabbit holes, let's introduce the second person here as well. And I'm hoping I'm going to pronounce and call the person correctly this time. Claire Ingram Bogusz. Bogusz, yeah. Interesting last name, by the way. But you're associate professor, right, in Uppsala University?
Yes, I'm an associate professor of information systems at Uppsala and an affiliated researcher at the House of Innovation at Stockholm School of Economics here in Stockholm.
Okay. Awesome.
Yeah, so bit of both, bit of IT and also a bit of business.
Yeah.
Although I trained as a lawyer before I did my PhD, and then my bachelor's is in economics and political science. So it's what in the US would be called a liberal arts sort of a background.
But you also got an award, right, for best PhD thesis, if I'm not mistaken.
Yeah, I got. I don't know if this is permitted with Swedish humility.
I
got
why I'm
go
saying
for it.
Okay. But you're South African, so it doesn't count.
Okay, well in that case, and I grew up in South Africa, but I've lived in Sweden for 10 years now. I got 2 awards for my doctoral thesis a couple of years ago. One for the best business thesis at Stockholm School of Economics, and one for the best information systems thesis in Sweden. That was 2018, and then I've since then got 2 more awards. The one was the Entreprenörskapsforum Young Researcher of the Year. That was last year. And then next week I'll get the Hedlund Award for Best Researcher in Financial Economics, because a lot of my research has been to do with digitalization in finance.
Fantastic.
Well done, Claire.
Well done, Claire.
Nice.
Thank you.
Wow.
Any Swedishness I may have felt has just disappeared because I've
that's
told all the things.
But then you have to go more into
then we are we need to talk about what have you been writing about that made so much of a splash.
So it's not to do with AI. It's to do with digital and collective entrepreneurship. So the things that I find very interesting, which are also why I studied law, which is how do people come together in the face of power imbalances, and do and build different things, and so law, of course, is famously slow and for many legal professionals famously frustrating because it goes so slow. Entrepreneurship, on the other hand, is also a way for these kinds of power imbalances to begin to be.
What?
So if we look specifically at the research that I've done, which is particularly around fintech, this perception that the financial system is, and it's not my perception, it's among people that I've collected data from, that the financial system is rigged in favor of the rich, the powerful, and governments. Right. So that's the perceived power imbalance. And then fintech, and particularly blockchain-based startups, have then reacted to that by wanting to build a more democratized financial system that redresses some of those power imbalances, particularly through the creation of digital distributed and democratized structures that are more inclusive. Whether they've succeeded in that is a whole other question. But that's what my research has been about. How do they organize? How do they work towards goals, considering they're not in kind of traditional hierarchical organizations, and the economic incentives that exist are kind of opaque and uncertain. How do we build this? So we talked earlier a little bit about open source, and a lot of those practices exist in open source. So kind of forking, ideological drive, identities, shared identities, social capital, because people get stars and know each other online, even though, or know each other's aliases even though they don't know each other. That stuff exists in the Bitcoin world, and that all then, or at least blockchain world, and all of that allows them to collaborate in pursuit of startups and infrastructures that can try to redress some of the power inequalities.
So is it right, if I understand it right, you were researching to uncover the core mechanisms of of these fintechs or this democratization movement, or I don't know how you want to frame it in the but in some way to understand the mechanisms, how it actually functions and could work.
Yes. I think that's a lovely way of describing it. Yeah. So again, particularly blockchain, because it's a extreme case which is very insightful, and a lot of that has been in finance. But then I also do research now on DAOs and Web3 with another researcher at Chalmers called Yasha Mansouri, looking at DAOs, where it's the kind of next generation, where it's not about democracies. It's not about finance. It's about other kinds of inequalities, and the internet itself, and big tech, and all of these things that maybe
any tangents to really deep dive on the open source mechanisms, because I think you have all this that goes into the blockchain idea and all this, but there's a fundamental open source mechanism. Is that part of the research?
Or open source mechanism or open source norm? What do you mean, the existence of code as
no,
open
I mean,
source?
So if we flip it back to data and AI, and the way it works, if you're a data scientist, it wouldn't exist if it wasn't for open source.
Yeah.
And if you look at this from the outside and you're not part of the club, so to speak, that is into this, it's really hard to understand the economic incentives.
Yeah.
And we are talking about this, and we have a joke where we ranked the top 5, from best to worst of the tech giants. And Anders always puts the one that does the most research in open source on the top, right?
It's not the only thing.
But I'm joking, right? But the whole open source model and movement is a huge part of where we are today, especially in AI.
Yeah.
So I was curious if you've been looking at that specifically
In AI?
The mechanisms of how
absolutely.
open source works, and why it works.
So part implicitly. So certainly the ability to fork and reuse code is a huge part of why you see. We would call it generativity, right? Like the reuse of stuff for completely unforeseen new opportunities, new use cases. But open source, particularly in software, I think is really important to note that it's well established. There are very clear norms, and one of them is that you don't fork, or not you don't, but it is really frowned upon to fork without having talked to the community first, and tried to resolve the dispute that you have that necessitates the fork internally. right? So that's a significant thing. That's the one. And the other is that there's a well-defined legal regime in the form of different kinds of open source licenses.
Yes.
And that's a huge difference as well, right? Because people have quite a lot of existing knowledge and also have both legal and normative frameworks within which they operate. And if we come back to AI, not so sure that exists in the same way, right? Because people are not. There aren't normative frameworks. There's a rush. There's an urgency that doesn't exist mostly in the open source world. And comparing blockchain and AI, a lot of the Web3 developers, not all of them, but many of them are ideologically driven by a desire to make the world a better place, right? To make it more democratic and fair. And I'm not sure we could say the same thing about AI research.
Probably not. I have a lot of subjective opinions about Web3 as well, and I'd love to, if we have time on the podcast or after, to go deeper into that, because I have a lot of thoughts, not very scientific.
But it's a separate rabbit hole to the whole theme of this.
Well, these are exciting rabbit holes.
Perhaps you can just elaborate a bit more. If you were to just summarize like the main contributions of the thesis, what would you say they are?
In 3 words.
Yeah, exactly.
5 is okay. 5 words is okay.
Generous.
I think it is the mechanisms whereby they organize, where these distributed collectives organize themselves in the pursuit of some kind of social good, without clear incentives and without the traditional trappings of organization, like hierarchies or rules or even boundaries that define who's in and who's out.
This is fascinating. From the outside, how can this ever work, right? And now you have tried to unlock those mechanisms.
Maybe. I mean, I think a lot of the research, the most interesting stuff is the stuff that Elena Ostrom did around collective action problems and around how regulations and norms can change. So a collective action problem is the idea that if everybody works together, we can create or protect something wonderful. So the classic is the tragedy of the commons. There is this common area. If we all work together to protect it, then it will be a nice green space for us all. But the problem is that individuals have an incentive to defect. They want everybody else to take care of the green space, and they want to let their dog poo on the corner, or whatever, do something exploitative. And so it collapses because everybody has an incentive to defect. And then how do you make this commons problem work? The one way is to have rules, to have laws that require that people take care of the common. The other is to change incentives, so everybody gets a payment because they take care of the common. And the third way, which is Elena Ostrom and is to change norms, where you have kind of societal and peer pressure that pushes people to look after the commons and to work together rather than behave individualistically. I think my stuff is interesting, but it is super narrow and mostly it's a tiny little weeny itsy bitsy ant-sized corner of this enormous intractable set of human problems called collective action problems.
How did you get into that?
I don't know. No,
super interesting.
I mean, it's a combination. I think that you don't come into a category of problems understanding what they are. I mean, I think given the background that I have, which is a massively unequal country, and the background of apartheid, and having political interests from always, that is something that I find interesting. What do we do about powerful people who behave unfairly, and why does this stuff persist? And this kind of anti-finance movement, and particularly these so-called technology and product-based social movements are an example where you don't do it inside the political system, but you build a product that does it, or technology that does it. And then it's only after the fact that you understand that this is not just about power. This is about like this problem shouldn't be solved because everybody wants some hypothetical awful government. Everybody wants the government to be overthrown, but nobody wants to go and stand in Sergels Torg with, you know, their whatever baton and their placards and have this is of course satire. The Swedish police would never run people down in Sergels Torg, but this kind of hypothetical alternative world, right? Everybody wants the change, but nobody wants to do it because it is just so it is personally taxing. And so this kind of collectivism, individualism tension appears all over the place, and you only realize after that this is what these questions are about.
Perhaps this is a good time to also try to move a bit into AI and continue the discussion on power imbalances, which I guess you find as a problem, and then we can find, you know, different ways to try to resolve them. And one of the biggest, perhaps, power imbalances that we speak a lot about when it comes to AI is what we call the AI divide. What we mean with that is we are, you know, playing on the words of digital divide from the past, but in this case we refer to that there are a few really large companies, the tech giants of the world, the Google, the Facebook, the Amazons, the Microsofts, and Chinese, you know, Tencent, Alibaba, Baidu, etc., that have extreme value, extreme large number of competent people, extreme amount of data, and very valuable services that they can use. And then we have the rest, the long tail, the rest of 99% of the companies that have nothing close to it. And it seems to be, especially with the extreme, you know, explosion and exponential growth of AI, especially when it comes to generative AI in recent times, increasing. So the divide potentially and the power imbalance to these companies is just increasing, I would argue. For one, do you agree with this? Do you see that there is a big power imbalance and it's potentially even increasing in recent times?
Or maybe it's bipolar, though, rather than unipolar. It's both in China and in the US.
Yes.
Right, so it's two modes kind of situation, yes. But in general, they're both tech companies. Perhaps one is more state-influenced than the other, but still the general theme is...
So there's not one powerhouse. There's a couple of powerhouses, but there are very, very few if you compare to rest of society.
Sure.
You call that bipolar.
Bipolar, so...
Chinese and US, two modes.
Yeah, two main...
two nodes, two geographical locations and legal regimes.
Legal regimes with kind of different, maybe different objectives even, we don't know.
And different freedoms and different norms.
The different norms. So it become bipolar because they're very different norms. You could summarize it like that. Yes. Good.
Okay, so then the question becomes, you know, what can we do to try to resolve this? I guess one issue is the access to data in different ways. We've spoken about that in the beginning, that we have, you know, training data that people use or abuse in different ways. But these tech giants have, you know, huge amounts of data themselves that they can for sure use without, you know, fearing of any kind of legal breach in some way. Do you have any thoughts, you know, if you agree that this is a big problem and it's potentially increasing?
Isn't it also what they say, power corrupts,
yes,
and absolute powers?
You listen to Lex Friedman, I hear.
I didn't. But I also read Max Tegmark's Life 3.0.
Yes.
But yeah, absolute power corrupts absolutely. And
yes,
I would argue that that tends to hold true.
And there's certainly an argument in Europe that GDPR has had a chilling effect on innovation, right? Like the counterfactual. Maybe we would have had a European Google, but for, whether you believe that or not. Is this something you've encountered?
Not that particular argument, but I have encountered that it has had a chilling
But actually,
effect.
If you go into this, one of the main forces for GDPR was actually to try to protect us and to address this imbalance. So GDPR came into effect to a large degree to sort of tackle the monopolistic power of, I guess, Google at that point in time. But in reality, it actually, it went, the objective of the law and, you know, the underlying purpose of the law actually, to a point what happened was when you have that competence, when you have the lawyers, you have the tech, you have the platform, you have the organized data in such a way that you're miles away anyone else, they could much easier comply with GDPR in terms of, you know, what we are, you know, we need to be legally forgotten. In an old legacy.
So do you agree that GDPR originally had the intent to at least fight some of the tech giant problems?
Giants.
Yes. But do you agree also that it had the opposite effect?
There is a great enforcement tracker. Goran, I don't know if you want to.
GDPR
enforcement tracker.
Yeah.
And if you look at the highest fines, then you can see all the tech giants up there. So it's not that they they don't go untouched, but also they it is. What many people know about the GDPR is that you can get sanction fees or fines to 4% global annual turnover or 20 million euros, but there we can see that it's actually much more that they have had to pay, but then it's only like a fraction, like zero. I think I calculated Amazon's fine to like 0.000.
And you only see one side there. You only see when they actually get fined, and they, for one, have the lawyers, as Henrik said, to actually fight at least potential claims, and get less fines that they otherwise could. But what you don't see here is all the companies that are too afraid to make use of data. That stops, as you said.
Yeah, exactly. Yeah, smaller players they actually want to take it seriously and not actually want to.
But let me test to frame this, because you can argue that GDPR on a microeconomic approach had the right intentions and effects, and you can see now that the big tech giants got the most fine or whatever. But if you zoom out like Anders did right now and look at the macroeconomic effects, it actually paralyzed. We slow down in innovation, we slow down in trying, we stop trying. We have numerous examples of quite nicely done, recommended system type services that was pulled out because we were afraid of dealing with it. So microeconomically, someone can, I'm sure, say this was a success. But macroeconomically, I argue that the tech giants had more to gain than what Europe lost. That is what I'm trying to.
And if I can nuance that further, it's there is a ceiling, there is a maximum fine under GDPR, which becomes a numbers game for a very rich company. How much do we make by breaching this versus what is the maximum fine that we can get, and so they can roll that dice. The very rich companies can roll that dice.
Yes.
Where little innovative startups cannot.
Budget. Yeah.
So that's an interesting thing that we are doing something. We had a purpose and objective of it, and on a microeconomic dimension, yes, it kind of works if you look at the tracker. But we haven't measured the macroeconomic effects of this. We can sense it. We think like this.
But then, Henrik, I would like to ask, why were the things pulled down? Why? What were the innovations that could have happened that didn't, and why?
No, okay.
I can give an example.
We can give many examples, but I think the most blatant and simple example is how data and AI has more or less slowed down for years in the public sector in Sweden because no one wants to deal with it. Bottom line, no one wants to deal with it, and bottom line, they don't have the competent knowledge, they don't have the access to lawyers, they don't have and we have then, if you add to this LOU, the laws around public procurement, we get to a really bad storm where basically, in my opinion, the public sector is more or less on a standstill in data innovation. Hardcore. That's my view on this.
I don't have a microphone, but I think that GDPR is a very profitable business. Obviously, 3 billion.
It's good for the taxpayers, perhaps.
Yes, 3 billion euros.
Do you see who got the fine?
Yeah.
Who was it?
Yeah, but you can get that.
No, but you see what I mean, right? And it's not like we're not doing it, right? We used something that could have done faster takes years. Something that couldn't cost a little cost a lot. But I think the main topic has been paralyzation, some form of paralyzation.
Yeah, and I think there are two sides of the coin here. So one is the fact that there could have been a lot of innovation that could have been actually harmful, and we don't have to, we can just recognize that is
very true.
A fact as well. But then absolutely, and it's very very sad. I've also seen very interesting interpretations of things. I think it was like also back in 2018 when somebody told me, "Oh, you're one of those GDPR lawyers. You know, I've been told that I can't email anymore." Or like
you can't get the parents' phone numbers for the other children at förskolan, preschool,
and
GDPR.
So I completely agree that there are many unfortunate.
But let's be nuanced here as well, because one thing is it a problem with the intention on the law, or is it a problem with how we executed it, how we implemented it, how we don't have enough? I mean, like, did we spend enough time and money and effort to build a guiding system or build a support function? We're going to put this law in place, and we really think it's a good idea. But then, as an implication, we need to put this type of department in to support public sector to get it done. You know, I don't really say it's a bad thing with GDPR. I think it's the implementation and the lack of support, in my opinion.
Yeah, and I think there are many factors at play here, but I think we also need to see the background of the GDPR. So there was a directive before the GDPR, and a directive is something that is then implemented differently in all the European countries. So some took a very severe take on it, and most kind of did not. And there were different levels of protection. So there could be a little bit of forum shopping, and some countries ended up with more tech giants than others, and these kinds of things. So the idea behind the GDPR was somewhere to make it all even, to raise to actually make data privacy a priority. So I think the intention was
fantastic.
Good.
Good intention.
Yeah, and
good
I'm not saying that there is generally something wrong with the way it's outlined, but I do think that it's a lot about how it's implemented and different variations of interpretations and also what is prioritized and what is not, and so on and so forth, and this
so it's hard to know what could have happened if we wouldn't have had it. I mean, would we have like a big cloud provider, as you said, Claire, right? We don't know, maybe not,
but I think, I mean, the main thing is that it was principle driven, right? At a time when there were these quite clear invasion of people's privacies. I remember listening to, what's her name, Margrethe Vestager, depending how my Danish is today, and her describing that the point here is to extend rights that people have in the physical world to the digital world, right? So you have a right to privacy, you have a right to individual integrity here. Why should you not have them? And then there are these unintended consequences, which maybe were not foreseen, possibly were foreseen slightly, but were seen as possible. What's interesting, though, is the AI Act has as an explicit sandbox provision, where GDPR is suspended, right? And so it's not like, it's like, whoops, GDPR had this chilling effect on innovation. Oh, well, there is some movement towards, and it's particularly oriented towards public sector, or at least to being done together with public sector actors, where you can kind of suspend GDPR under conditions of oversight and transparency and all these kinds of things. And I think that's really interesting.
But this is a learning. I assume this is a consequence and a learning. That the act and the principle driven is fantastic, but careful in how you execute and implement and invest in the measures where we have risks of chilling effects or whatever.
But it's also easy to see some real concrete negative outcomes, which is like the cookie law that I would really like to hear someone argue for.
What is it you mean?
The cookie law, it is from the e-privacy thing from the beginning, and then when GDPR came into place, you probably know this better than me, but when with the GDPR, it also made it, they forced everyone to have consent to use cookies, and that made all the pop-ups we now see today after the GDPR came into place.
And then Schrems too, where we got these more nuanced cookie laws, which are these huge, great big things with lots of moving buttons.
But
there
are many things. Many things. I'm not gonna lawyer this too much.
No, lawyer. Tell us
but it's absolutely true. So the initial intention was that the e-privacy directive
from
would be
2007-8 or something.
Isn't it 2? I think.
Okay, good.
I think it's early. Because if you remember, it used to be, and it still in some cases, like I understand that we have cookies and that's it. Not even I accept or something, but just like
because it was in the original e-privacy directive, if I right,
and it's still
it would be okay
it's still
to
applicable.
Have
like we
right?
don't have the regulation yet. So what they wanted to do was also to make a e-privacy regulation, and that has been on the table for now 5 years plus. Yes. So that is it doesn't apply right now. So what we are So but what happens was that the e-privacy directive, and I really hope I get this right. It was referring to the previous directive that is now GDPR when it comes to consent, and what is and the requirements of consent in the GDPR. It has to be there are many variables that need to be taken into consideration, and it needs to be freely given, and you need to be able to withdraw it, and you need to it cannot be mixed up in other requirements, etc., etc. So that is how, and then there were some. I don't remember it by heart now, of course, but there were some decisions I think made in the European Court of Justice that then laid the basis of the cookie banner that we have today. So it's an interpretation of the directive, because the e-privacy regulation it doesn't exist
but
yet.
The GDPR regulation forced it to be an explicit consent, right?
Yeah, because that is the
concept. I guess no one thinks it's a good idea because it caused some kind of consent fatigue in some way. So everyone is clicking the button and doesn't even read anything.
Yeah, but I personally I became aware of how many cookies are actually, because I am one of those who actually obviously go in and like decline everything. And yes,
I actually do not. That's okay.
Okay.
I cannot go into that if you
I
want
will not
to,
use your computer. Anyways, so but there you can see like list after list after list of various. So I don't, for me at least it was eye-opening to how much is actually placed. Why?
Yeah. I'm biting my tongue here, but just to go more into, I think if I just summarize what you said, the e-privacy directive did not really have the intention of forcing, a pop-up to come up on every web page, right?
E-privacy is very old. Yeah.
But then something changed, and they basically, because of the
GDPR
regulation, and now I think they're updating the e-privacy one, EPR, to come up with a new regulation that is actually going to downplay this, so they can resolve the problem
that is one of the things that have been discussed. But I mean, there's it's called, I think, the electronic privacy communications directive, which
EPR,
will be but e-privacy.
Yes,
exactly. So it comes from there,
But you must agree that the pop-ups is a problem, and it's causing not the effect that was originally intended. Even if you perhaps personally, went in and looked at the cookies, for mainstream of users, they are just getting annoyed and potentially clicking no to a question that should be yes.
But I think it's a very good question to ask. Why do we use? Sorry for those who are watching this, but why do we use cookies to begin with?
Yeah.
And is it always valid? And is it always valid that we have? And because it's not very, and I agree, it's not very transparent. Not even how it's done today, because nobody cares to read.
There is also technical solutions that can, use other solutions than cookies.
Have you tried Apple?
Of course.
They don't have a cookie banner. Have you? Yeah.
But there are other ways to get around this regulation. They still have the same effect as cookies has, because cookies has a really good, user experience purpose. Some of them have bad purposes for sure. But
yeah,
for many
absolutely.
purposes, they
Yeah.
are necessary.
Yeah.
You won't have a functioning website if you don't have similar kind
Absolutely.
of functionality.
Yeah.
And then you can get around it, and then suddenly, some people or some websites or companies are able to have a much better user experience, no pop-ups or whatever, but still the same functionality because of a technical fix. That is a really bad thing, I would say, right?
But if I can put a word in for marketing as well, right? Like if we want the internet to be free, or much of it, then we pay with data, right?
Yes.
Then it becomes a trade.
And
if we don't want to pay with data, then we need at some point it will come to the point where we have to pay.
Yes.
And I don't
Which
know.
will also cause a divide between
this
those
is
who
also
can
true.
and cannot.
Yeah. So free services is a luxury we've had
Yeah.
sometimes.
And it's not free. That's the point, right?
Yeah. If you're not paying for the product, you're the product, right?
Yeah.
Exactly.
Yeah.
That's the one.
Free. Yeah.
Still, it has enabled people to use services that have extreme value and some abuse as well. But for a lot of services that we do use for free, like Google Search, it is, enabling people to have knowledge that they never had before, in extreme sense. So, and that is completely like ad-driven kind of service. So, it does provide some positive value by having that and having cookies connected to it. So it's not only negative for sure, and cookies are not only in some cases, I would argue, necessary, but they're also useful even for users, I would argue, in some cases. But there are abuses.
Yeah, I don't argue with that. It's more about how transparent is it actually, and what are you giving consent to? Do you absolutely understand what everything will be used for, and so on?
But imagine the intellectual overhead to understand. How many websites do you go to a day?
Yeah.
Do you want to understand the cookie policies of every single one? Like I would get nothing done if I had that burden.
It's a horrible user experience for sure. Right?
Yeah, and that is only the cookie policies, but then we have the privacy notice and says, etc. And there was actually a study made in 2016 where I think the findings of that was that it would take you 76 days to read all the privacy notices of all the services you use in a year. And that was 2016 pre-GDPR. And in the US.
But do you agree that this was a bad consequence of GDPR?
I don't think this was actually a consequence of the intention behind the GDPR.
It wasn't the intention, but it was a consequence, right?
It was a consequence of how the e-privacy directive...
But the e-privacy didn't want to do this. When you had e-privacy in place before GDPR, there were no consents and you didn't have to do it. It was after GDPR came into place that these kind of pop-ups started to appear, right?
Yes.
So it was a consequence in
and
some
how
sense.
that was interpreted and decided upon later.
Yeah.
Yes,
It is.
It is what it is.
It's good that you try to defend GDPR.
No,
it is.
I'm more trying to defend the right to choose and the right to transparency and know what's going on and know when you're tracked and knowing why you are being tracked and so on.
Yes.
So that's what I'm defending.
With.
So the means of doing that is then up for debate.
So we're back to the difference between the objective and principles versus implementation and execution of different things.
And also the balancing, right? I mean, on the one hand, we can all agree that transparency and privacy are important, but they're very inconvenient when sometimes, right? Like because if you have to understand and consent for everything, that's exactly the
problem
thing with GDPR as well, right? Like we might agree with it in principle, but it's pretty cumbersome and impractical. And where do you weigh up principle versus pragmatism?
Isn't that the same problem as the terms of service agreements? You all have to agree to whatever kind of service you use on the web, and no one reads them. Isn't it the same kind of fatigue that you have a consent now start to appear?
Maybe what is a loyally boring question in a way, but so there's this tension between so-called freedom of contract and fairness of contract, right? Where in some legislations, and particularly in the UK and the US, you have freedom of contract. You can agree to almost anything with almost no limitations in the name of fairness, right? And in Sweden, you have something very different where there is a lot of kind of fairness things decided ex ante prior that you cannot contract into. Right. But in some countries, you also then have courts will kind of prefer one over the other, and this feels like, and one of the arguments, at least in South Africa, is that nobody reads these contracts, right, and they can have patently unfair clauses, and because we know that nobody reads them, courts are hesitant to uphold them. I'm wondering, and this is a question to you, if there's ever been such a case with these enormous, I mean, Google has its updates and it's like pages and pages. I don't read it. You don't read it. Jannika reads it. But that's actually to her detriment, right? Because then she knows and understands, even if it is unfair. Are there cases where these unfair contracts have been turned over either on the basis of unfairness or because pragmatically nobody reads them?
Are you talking about terms of service now?
Terms and services, yeah.
I don't
digital
think that much
no?
with that.
Okay.
Because that tends to be more the commercial side of things and not privacy, because that is more like privacy notice, and then the addition, the data protection addendum, that is added to it. So.
Yeah, we'll look it up. Sorry, that was a nerdy tangent.
But I think it's a very good point. The fact, and it obviously is a problem that nobody reads these.
Yes.
How should we do that differently?
I mean, I think what Sweden said and what you said about the fairness of contract is actually a good thing. I mean, you should help the user. The regulation should be of help, not an hindrance for users, especially, but also for companies, I think.
But say Google were to update their terms and conditions, or you, next time you download something, you need to, instead of read and accept, what is there instead? How would you see it, like as non-lawyers, that would be done?
I don't have an answer for that.
This is a super good question and a really good pushback. What's the alternative on these things? It's super hard.
I think AI could be of help here. I mean, and then, if you
we
have a super complicated terms of service agreement and you simply ask some AI service, can you please summarize this agreement for me? Yeah. And they actually become a help for users. Perhaps that could be a way.
Or you have a service on your computer which where you've decided I will agree to these kinds of cookies, and then the LLM goes in, reads the cookie notice, and says this one I agree to, this one not, this one not, this one not, based on your prior.
I think exactly like this is where this is. This is actually that's my answer.
Yeah, what she said.
No, because. This goes back to like any development. Like it's not feasible that we do this one by one. We need to install some other microservice who does this for us, where we put in, like you talk about, attribute-based. How you do access and stuff like that. Role-based access becomes crazy when you have a lot of data, and we can do so you can put in the microservice.
ABAC or RBAC, yes.
RBAC, right?
ABAC is attribute-based
access control. ABAC versus RBAC. Have you heard that expression?
And sorry, what is R then?
So role-based access control.
Yeah, okay.
So when you build systems and you say, we have an ERP system and the financial guys should see this, the sales guys should see this, the head office should see this, and the business unit should see this. And then you start building up these roles. And when you go into a data platform with a lot of data, the mutations of roles becomes enormous. Cannot be done. Then you switch to ABAC, attribute-based access control. So you basically say, these are the flags of different attributes.
What would an attribute be in this case?
Country, function, whatever flags you're doing. Yeah, you can explain it better.
I think, what you said, either you have a service. I think there are some examples of the upcoming web browser standards that are going to implement in the web browser instead these kind of settings, as you said. So you can basically say, I don't want to have any kind of ad-related cookie. And then it could be an AI service that interprets the cookies or the terms of service agreement to comply with a more attribute type of preference that you have. So you can choose your preference in a simple...
Like on beforehand. This is what I will agree to and this is
Yes.
what I don't. And
Yes.
then...
And you say that, okay, I accept to have much worse ads because they can't read who I am. And I want to have then bad ads in favor of higher integrity. Or I choose to, I'm open to share some data that I have. But in that favor, I get actually good ads. And perhaps the service otherwise in Spotify can know, what songs to recommend to me in a better way because I can share the data about me to a higher extent. And in that way, you can choose your level of integrity that you want to have.
In a simple way, you can then be guided through this attribute. Do you like it or not? And then you can sort of summarize. So I keep the cookie functions for this reason, but anyone which has to do, they are spreading my data to third parties or whatever they do, no. That attribute I don't agree with, and then you turn that off. So this is attribute-based approaches. And then basically you collect that in one place. I think that makes a hell of a lot of sense that someone needs to figure this out.
Yeah, so if you're listening to this now, this is your cue.
Go
and do it.
This is the startup idea.
Yeah.
This is the killer app. I would choose this web browser any day.
I see the time is flying away, and I really hope that we can have some more philosophical topics as well. But we have a large number of more professional topics to cover as well. And perhaps we can let you choose a bit here. Or can we take one ChatGPT question at least? And everyone is speaking about it, and I think it's so fun and important to speak about. So
please,
yeah.
Is fine.
And all of us know what ChatGPT is, and there's been one country, Italy specifically, that actually banned the use of ChatGPT, and now they re-enabled it after OpenAI made some changes. And let's see if I remember correctly. I think it was surprisingly small changes that OpenAI accepted, and then suddenly Italy completely, and their DPO or whatever the kind of data protection service that they do have.
Yeah, supervisory authority.
Yeah. And
what was the basis for the Italian decision? That
privacy.
Was it just privacy?
In some way, how they were collecting data, or how you would do it.
Perhaps Jannika knows.
You know it better. Please do it.
Sure. First of all, this is a decision by Garante, the Italian supervisory authority, based on the widespread, but also there was a data breach of some kind in the background when it comes to the subscribers' data and the users' data and how that was somehow deployed. What they said, it wasn't a ban, but it was a immediate limitation to suspend the use of ChatGPT in Italy for Italian users because they were doing that unlawfully. It wasn't in compliance with the GDPR because they didn't inform correctly how the data was going to be
and that's not
processed.
The training data in this case. It was simply the data of the users, right, when using the service. Wasn't that correct?
I think it was also about the training of the data. There was
sure?
also because
they
I
didn't
read it
change
from
that.
I can't say that, but what I read from the Garante homepage webpage, it was also about like how they train the data.
Yeah.
But it's trained on user data as well, right? So there's the original.
Let us be clear here. I think for one, they had a huge amount of training data that they trained the big model on, but they also potentially will continue to fine tune and train a model on user data while using the service. So if someone writes a question and they get some answer, they can use that data to continue to train the data. And I think that was the specific thing that they needed to have consent to do. There were three different things. So one was the transparency and providing information, and also the legal basis of that. Meaning, in order to handle and process personal data, you need to do that lawfully. How do you do that? You need to be legal. You need to be able personal data is basically that you write a question to ChatGPT, and that kind of data that you write as a question is potentially user data.
Yeah, you could input somebody else's data, but they could also have your IP address and so on. All of that is personal data. They need to. So what is the legal basis? And I think it was actually the legal basis for training. So how do they justify why they are training on personal data?
Yes, but specific data of using the service, not the other data that they collected in the past.
You might know that better than I do.
I think so.
And then so that was one point. Then there was the fact that I think it was only in the text that that this was aimed for or that they didn't want children to use the service, but they didn't make any kind of validation of age. Right. So that was also another thing that they had to do. And then it was about the I think it was also about the data subjects, right, or something. Anyways, that the ability to opt out from not being and so on. But actually, I went to look at. Well, now I'm not logging in from Italy, and I don't have. Yeah, so I haven't read the Italian versions of things, and actually, it's actually quite hard to. I don't know what you actually read. Did you only read the privacy notice? Because when you go to their webpage where all the policies are, you actually have to subscribe to some, or you need to provide information in order for them to send you that, which I think is pretty interesting.
Sorry, I didn't get that. Can you?
Okay, so if
you have to tell them that you want the terms and conditions. You can't just click a button. You have to, like those. You have to send them extra information so that they have a record of specifically who has asked for their terms and conditions,
which they probably also use for something.
So it's just
But and if you would like to, you can just show them how that is.
So they basically ask you to send them the terms and conditions, so it's more complicated for you to agree to it, or
and also then they have a record of who's agreeing.
Yeah, and who's
asking
reviewing,
for a copy.
who's wanting, what information.
So you need to do that anyway. I mean, if you logged in and they click a button, they have a perfect record of that anyway.
Yeah, but they don't have your name and phone number, and there was a lot of information.
They just have an IP address.
So OpenAI .com, I think. And then scroll down, and there is security, I think it was called. I love when we can get legally nerdy. Up. There, security. Yeah, click on the To Our Trust portal. And scroll down.
Typical example of how tech giants can comply with GDPR.
This is why Jannika reads the terms and conditions.
So if you click on employee privacy training or data breach notification, click on that data breach notifications. Yeah, here is where you need to provide information in order to receive it. So it's not that transparent. So I'm just wondering what exactly.
But this is a data breach notification. This is
that's
if there's a breach.
Yeah, exactly.
This is not for the terms and conditions.
No.
So if you were to claim data breach, then you have to fill this out.
No. If you want to, so in GDPR, there's a requirement that if there is a data breach, the company that's looking after the data has to let you know within, I think it's 72 hours, right? And they can't let you know if all they have about you is an IP address.
Okay, but there's also employee privacy. I think cookies was also something. And then I always go for the data processing agreement, which was also.
But 99.9 users will not go through this, right?
No, absolutely not. And I mean, I didn't want to provide them more of my data, so I didn't do that.
Yeah, it becomes a GDPR issue to actually comply with GDPR.
Surely you have like I call it
so funny.
Surely you have like a dustbin email address,
This is so interesting because,
for
example, so now you have double terms of service and double terms of service and privacy.
Yeah.
So imagine if you first have like a privacy terms of conditions for the normal thing, and now I have read and agreed, and there's a different terms of services for this particular part, which says like you cannot sue me if you see something that is not good. Then it will be.
This
and
is
you don't
really tricky stuff.
Yeah, exactly.
But this is what you
Breach
highlighted.
everything.
This feels weird. This is what.
This is smart.
And this is the privacy policy that I read though.
But imagine if every
maybe
company and every
that you read
startup and all people that want to comply with GDPR has to implement all of these things. No one could build a service like this. It's only the big tech giants,
we need to find
right?
a better way.
Yes.
Yeah.
It's a clear problem.
And absolutely not having somebody subscribe to something in order to, I don't know.
And it's obvious for the tech giants, this is not a problem. They're even smarter than us how they implement it, you know.
They'd get an LLM to build
hard.
it.
Probably.
And make it a bit difficult, and then you hide it. So it's called security, and you don't necessarily make the connection.
Okay, awesome.
Yeah.
So what do you think in general for services like ChatGPT? One is the data that user provides while using a service, which I think this is really targeting. The other is simply the training data, and it's connected to the Drake example we gave in the beginning, or also the GitHub Copilot example of having an awesome AI model that can help developers code by using other people's source code, and Stability AI for being able to generate images on other images. Is it okay for ChatGPT and GPT-4 models to train on all of internet, text data to be able to build a model like this without having specific consent or anyone saying use all of the data on Twitter or whatnot to train the data? Is that? It sounds weird, doesn't it? Right.
It's. I think my main question is a pragmatic one. How would you get consent? Right? So that's the one part. But the other part is, do we reasonably expect that data released into the internet is private in any reasonable way?
But you're not allowed to take information from a website and redistribute that in other forms already today. So why should it be allowed?
But that's again that's copying, right? That's redistributing the same stuff. It's not copying. It's not plagiarism. If I were to go and read this OpenAI terms and conditions and
exactly, they claim it is plagiarism because you used it as training data.
But the difference there is that is copyrighted, right? Those are not just things that you put on the internet. That's not me writing on Reddit. That's copyrighted.
But you can put a lot of stuff on internet that is copyrighted. I mean, a lot of stuff on GitHub is copyrighted.
And then also, how do you distinguish, right? It's not like, so if we had a Web3 solution.
I'm going to go Web3 soon.
No. I mean, it's a half joke, but it's also, there is no system for routinely flagging ownership online, right? It's not one of the characteristics that you can identify on a website. So my question is mainly a pragmatic one. How would it be possible? And these would not have come to be if they hadn't done that. If we go
a bit technical here, there is for web search engines a practice, if they are allowed to index data or not. So you have the robot.txt that you can put on any website, and that tells Google and all the search engines to either use or do not use. Couldn't you find, I heard some people argue at least, that this could be a solution for AI systems as well.
Okay.
If you simply put
and that indexing is for search engines specifically.
Yeah, robot.txt.
So but it would be an analogous for you can use the AI. That's
a training
cool.
data, right? So
That's
if you simply publish a small file saying you're allowed to use this part for training, but not this part. And if someone were caught later to use that data still as training data, then they get sued.
That's
isn't it some, as we talked about before, there are mechanisms that doesn't exist yet because we haven't considered them that will evolve. When we understand this better, like we talked about, how do we get out of the cookie problem? We solved that one already.
Yeah.
One startup. Now we need
Henrik's going to start.
I do have something
tomorrow morning.
I do have something to add to what you were saying, but addressing this isn't that how things always work? Before the internet, we didn't have a right to be forgotten because it wasn't a problem. Because we are creating new solutions, and with new solutions come new problems that we need to.
Someone said exactly this. I read this somewhere else. I fully agree with this comment.
But also by making mistakes, we can also build better things, and even doing things in ethically gray areas at first, maybe you can have a better thing later. So how many of you, do you remember Napster? Right, like such a bad user experience, so bad, and obviously like ethically, legally, massively problematic.
Did you use it? Yeah,
I am old enough to have used Napster.
And Pirate Bay as well.
And Pirate Bay, exactly.
Yes.
But then the next generation is not only ethically better, but a better user experience, right? I can't help but wonder if that will be the case here, right? Because a lot of the basic research is being done now, and then the question becomes how it is used, right? Go ahead.
No, please continue. But I have a continued line of thought from what you're coming from now. But finish yours first.
No. So my point is. Now I lost my point. Anyway. I mean, I think there are two lines of argument. The one is we can learn from these mistakes and we can build back better. But the other argument, and I think the people who are really scared of where AI is going is that there is no going back from here, right? That this is fundamentally groundbreaking research that will change things, and we can't just build better versions that solve the ethical and legal problems now, which is why so many scientists are saying let's have a moratorium until we have some consensus about how to do these things.
Okay, so there are two strands of thought here. I'm going to go with the second one. I think some of you, when we were thinking about what to talk about in this pod, was it you, Jannika, who mentioned there's been the social dilemma? Was a Netflix movie.
Yes.
And now they actually came out with a quite interesting 1 hour talk on the AI dilemma, where they basically highlighted. We couldn't foresee some of the implications when we started social. We didn't understand what the consequences were, and then the argument is more or less like, this is the no going back. Like, we need to figure this out now before we end up in the same dilemma, but maybe with much more severe consequences. And I think that's one part of the argument here. The other side of the argument, which is actually where I was first going with this, was it's very, very hard to understand this if we don't try and experiment, because no one can really foresee anything. And I read an article with what's the woman's name? The CTO of OpenAI. I forget her name.
Mira Murati, right?
Yes, I think it's Mira Murati, right? Yeah. There's a female CTO of OpenAI.
I think that's her name.
And what I think she was doing a very balanced answer on these topics. And this is basically that we really don't understand, so we are trying to in a controlled way experiment and stepwise learn, but we cannot understand and get further if we are not seeing stepwise what is happening. So I can resonate with that is true. The problem we have now in the middle of this is a fundamental arms race where this has sped up incredibly in a which I think the actual race is what is scary now. Because some of them would.
Should we frame this as a question somehow, so we get the proper topic? And perhaps the topic could
I don't
be,
know.
You started to speak about the moratorium, and it's connected to the arms race then.
Yeah.
And perhaps if we try to phrase this as a question, let's start with the moratorium then. I mean, we had a number of very noteworthy people like Elon Musk and Max Tegmark, etc., who claim that we need to take a pause 6 months on the AI development for anything more powerful than GPT-4. But what do you think about this? Is a moratorium a good way forward?
So I think Henrik set up a really good groundwork for a response to that. And when you conduct an experiment, there are rules. There are procedures around how you document what you're doing. If you have a control group, you have an affected group. You have ways to make sense of what you're doing ex post, and to proceed in ways that don't violate ethical concerns that we have ex ante, right? So whether it's get permission to test on animals, or if you're doing social science that has to do with vulnerable populations, get permission for that. All of these things exist for experiments. I'm all for experimentation. where are the rules for this? And for me, that's the concern, right? It's not that AI is intrinsically okay. Actually, it is intrinsically something that maybe we should be worried about, but that there just aren't any rules, and so this open letter doesn't just say there should be a moratorium. It says maybe if there was self-governance, if there were rules that were self-imposed, maybe we would think differently. But there isn't even self-regulation here. And that's the reasoning for it, and that makes sense to me. But the counter argument, of course, is, rules are only as good as your ability to enforce them.
And the challenge will be that how you impose this on everyone.
Exactly.
And then you impose it, and we abide to it, but the bad boys
exactly
will not.
So some countries do, and other countries do not, or people who manage to do things outside of any kind of particular jurisdiction, right?
So you basically think it's a good idea of the moratorium in that sense, because they need to look back.
Yeah, I do, but
it's
impractical, right? It's a principally good idea, but it's impractical.
And what you're really after is that we get. You frame it so well now. I can't copy it. How we get the rules and ground rules and then experimentation that is done in a scientifically good way, ethically and good way, so you can understand afterwards so that kind of thing, and especially when you're in a race, then that is sort of really tricky. And it's so big stakes right now.
And different rules. Maybe I mean it becomes a competitive disadvantage to have a CTO or a CIO who's sort of ethically inclined in this particular race to the bottom.
I think I mentioned before.
Is it a race to the bottom? If we go I think it's an interesting song, because you're racing like crazy now, but if you're racing without any thought, it's driving a motorbike, right? You want to race, you want to win, but you damn need to stay on the track to win.
But would you release a car to the market without safety requirements as well?
That's a good example, I think. I think also I changed my mind actually after the initial news about the moratorium to actually be more positive. Listen to what Max Termark spoke about it, and I think he phrased it well. I think what you said also, Henrik, is that we have a problem with the tech giants today. We have a problem that they are a commercial company that is responsible to their shareholders. If they actually stop developing and actually not competing with the main competitors, they will get fired.
And sued.
Potentially.
Or shareholders.
Shareholders could even sue them for not racing.
So then, it's hard to even to hold a CEO or C-level people and responsible for this, because they are required to take the race. And then really the question is not really even if they wanted to. He says even the most the best CEOs of tech giants are good people. They don't want to harm society, but they have the responsibility to continue the development as the fastest rate possible. And then how can we help them?
How can we help them? This is a good way of framing. Yes. How can we help them to race for the better of all?
And one way to help them would be to build like a public opinion saying it's going too fast now. And then it's coming back to what you said as well. We don't have the rules for AI development. We have no fears of pushing an AI system out to the market as we do for a car, or as we do for an airplane, or as we do for a medical machine that we are starting to use for brain surgery or whatnot. So there are a lot of rules for other systems, but perhaps not for AI systems. And that by simply building a public opinion, it could help companies to slow down or put more.
It's not completely wild west. We do I'm talking about Europe now. We do have regulations in place, such as the GDPR, etc., that do apply, even if it's not like AI is something.
No,
it doesn't go under the radar in that way. The long arm of the law can still reach it, but I think the AI Act would help. in this regard, because then you would be obliged to make risk assessments depending on how high risk the AI system is, and there would be transparency requirements. Well, we can also go into that because we talked about transparency before, and so on. So if it doesn't come from inside the organization, and it doesn't necessarily, because would it come from the market? Maybe, because people are aware, some are aware, but I'm also very divided, because I have tried DALL-E 2, and I think for me it's magic, and trying GPT-4, it's also like you are mind blown and understand the fascination. So it's very hard to also understand that there's an underlying threat here.
But
sorry.
Please.
Yeah.
Continue.
And then comparing that to our use of social media, I think it's the same thing there. We reap so much of the benefits of that that it's hard to go without or pressuring. Like, who is pressuring Instagram? Who is pressuring TikTok? Really?
Now I need to butt in.
Yeah.
I got an epiphany when we talk now about problems, root causes, and symptoms, and we try to find solutions. And it's very important that we put the right solutions that doesn't solve symptoms but root problems. And to me, it was an epiphany arises when Claire has put on the table that we need experimentation, but we need proper standards and procedures and scientific approaches. And on the other side of the table, we can say, we need AI regulation to help with that. And then now comes the interesting part: will the regulation help us to devise better experiments, or will it? So it will force us. The regulation is going for the symptom, in my opinion, that we're doing something bad, but it doesn't help us that no one really knows the good practice of experimentation. I don't know. So I'm saying the AI regulation will be very important, but what I think is more important is how do we get then guidelines out? How do we get test beds, sandboxes? How do we get procedures out? What is a good experimental approach? Do you see the difference, right? So one thing is highlighting, I'm going to punish you, I'm going to regulate you. You need to do you need to have done this test, but it doesn't say how you should do it. And I want to know, okay, please, could we get a practice here? Can we get a consensus about what is good experimentation then? Yeah. I think it's a massive difference in how much investment you should put over here and over here.
Or is it forbidding in a way?
So you need the regulatory act to sort of put frames and like this. Yeah. But what we really need is the scientific approach of ethical experimentation.
Or norms.
Or norms, right? Norms.
I mean, I can't help seeing this as a commons problem, right? As a collective action problem, in which case there are different things. The one is financial, right? If we make it financially beneficial to behave in a collectivist way, and one way to do that is to boycott, or we create regulations, but as we know from GDPR, they're kind of static, and they have unforeseen consequences, or we have norms, and I think another way. I mean, this is what this letter is doing, right? It's saying this is what your peers think. These are the norms. Yeah, absolutely. I don't have an answer except to say that, but I have one really difficult thing with this, right? So there are these famous experiments that would never be ethically allowed today, right? So during World War II, they did these starvation experiments in the US, the Minnesota starvation experiments, right? That would never be ethically allowed today, but it has advanced basic science an enormous amount. There's the famous Stanford prison experiments, also like really important to understand human psychology, would never be allowed today. And for that reason, regulations become, because they are so static, and it takes time to agree, and you can only remedy the things after remedy the problems after they've been done. That's almost suboptimum, whereas norms, if you can, they're harder to achieve, but they can be more effective because they're much more flexible. So that's the other question, right? Are regulations the way to go, or are norms the way to go,
or a combination,
or a combination?
But so as a researcher, when you look at the moratorium, you look at this directly from, okay, they're trying to establish some norms here.
No. One doesn't. Researchers don't look
jump
and know. They go, that's interesting.
But did you reflect in that? Because I immediately now, when I've learned some of these, what you are doing, I can immediately apply that to. Are they thinking about norms now when they're doing it, or?
I presume they are. They're much smarter than me. They're calling for both. They're saying this is so urgent that it's all guns blazing, right? It's regulations, it's norms, it's boycott them. This is urgent.
I mean, perhaps it will be a consequence that in coming releases of AI models, if they don't at least try to conform to the norms that the public opinion now is starting to form, they will have consequences of that. So perhaps they are, even if there will not be a formal moratorium, it could still have the positive effects that we're looking for.
Or as you said, Henrik, the CEOs can go to their shareholders and say, this is the tide of public opinion. If we don't do something about this, they're going to boycott us, and they're going to all use DuckDuckGo, right? Or okay, that's not an AI service, but rather than Google.
No, but I think that's exactly where I was going in my head. That actually, what will be most powerful if you want to slow down the race? Will it be AI regulation, or will it be when the CEOs understands the economic effects of going against the norms of society?
But then we really need to create those economic effects and to have the norms.
No, but you and me create economic effects by boycotting services. You and me create economic effects when we say, Tesla is the only, I don't want to buy another electrical car because everybody else has not figured out how they do charging. It's only Tesla, That's how you get economic effects that the CEOs understand.
Absolutely, and I would love to believe that can be achieved. But considering how we deal with social media, for instance, I am a bit worried.
I haven't touched Facebook in 3 years.
Yeah, but most have.
But you use LinkedIn.
I use LinkedIn.
But I think we are aware. But I think I would argue that most people are not aware. And that's why we need masses, I think, for this to work. But I like it, so I'm not going to argue against.
Can it be done? I don't know.
Like, how can it be done?
So you have the research. What does
Claire,
it take to get norms done?
But this is still a collective action problem, right? It's just the other side of it, right? Yeah. Everybody wants everybody else to boycott them, to protest on Sergel's toy, but not me, because I like
ChatGPT.
Yeah. Which is exactly what you're saying, right? Then we're back to regulations.
And as the time is flying away, we haven't really properly spoken about AI Act either. So perhaps we can have at least and try to keep it short if we can. But I guess
don't blow your
because the last question couldn't be solved anyway.
You say that as though they all can.
Well, let's see if we can find a good formulation here. We already mentioned AI Act a number of times, but let's phrase it like this, perhaps. Will the AI Act regulation be able to find the right balance between both, I guess, human safety, but also innovation, which GDPR, I would argue, did not?
The way that the AI Act is, or Claire,
you go ahead.
Okay. The way that it's sort of built up is that there are, after all the definitions and everything, you need to know the level of risk that you're, and it's talking about AI systems, and that's a very interesting thing in itself. And what is an AI system?
And where are the boundaries?
Exactly. So is it low, medium, high, or is it like unacceptable, forbidden? And there are a few practices that are, and so it's. and again, this is about like, is it allowing or is it or is it forbidding? And what it does, it's basically saying, hey, this is not acceptable. Here are some practices that you need to do when it comes to the risk level of your AI. But when you have done that, everything is fine. And again, it's a regulation. No country gets to regulate their own, and it specifically states that this is the limit. And again, because they don't want any stricter
compulsory law that everyone has to use.
They don't want an imbalance Europe on these topics.
Yeah, exactly, because they do want us to be competitive in Europe, I would argue. And then there's the sandboxes and everything. So yes, this needs to be done. And after that, innovation, sort of. So yeah.
But they don't ban them. Even the high risk ones. They say where you feel, at least, I mean, of course it's in draft form. They say in these very high risk ones there are particular standards that you have to adhere to. They have to be CE marked, and you have to have higher levels of transparency because of the risk involved. Are the very high ones even banned? Or
but there are three different levels. The low ones, the medium, the high, and that is, in my opinion, what you're talking about. Then there are the like biometrical
social scoring.
Social scoring.
And those are completely banned.
My understanding is that they are banned.
Yes, they are.
Okay.
Sure.
Okay.
Yeah. Okay.
But help me here, because the confusion arises when I try to dig into this. That I find that there is some sort of mix, and we have used this analogy before. If I have a hammer, I can use it for many things, and of course, I can hit Anders in the head, and
you can also build a house.
I can also build a house. And what is the problematic thing with AI regulation to me? I think there's a mix of trying to regulate the hammer and trying to regulate the use of the hammer. And I would argue that AI, and especially now when we talk about the big breakthroughs with transformers, which are multimodal, and we start realizing that all these different techniques that were used for very different use cases, you had computer vision had one technique and then this one. So you could kind of follow the technique down to a use case, right? Now we're getting to a point where it's converging on some techniques that are very powerful to use for many different things. This is one angle. And ultimately then it becomes really truly general purpose technology like electrification. So how can you regulate, then it starts to getting blurry, isn't it the use cases you should regulate? I'm confused now where the AI Act stands on this.
But I think my understanding is that the AI Act explicitly requires that the general purpose technologies have the same what are they called? Transparency requirements, and they also need to be CE marked. So they're not prohibited or banned or any way.
There's a lot of requirements
there are a lot
to be able to work with a high risk system
outside of a sandbox.
But what constitutes now a high risk system? Is it the types of techniques used, or is it the use cases?
But what they say here is they classify general purpose technologies as their own category.
That you mean the generative AI?
General purpose, so LLMs, image recognition, all of these. Generative. Okay. But they're treated the same as these kind of middle to high risk, so not banned, but heavy transparency requirements. So they're not looking at the outcomes. They're saying, as you're saying, we can't be sure what the outcomes will be, and so we need transparency with them.
I mean, because I think the point I'm making, if you're using LLMs for something fun but trivial, who cares? Who really cares? I want to make pictures for fun at home, and who the fuck cares? Just do it. And then I'm using it for a use case that are clearly very bad. Why should they have the same regulatory requirement? One is for toys, one is for play, and one is for war. They're all the same, but one is for war and one is for drawing pictures in a book.
But isn't the point that it's unforeseeable?
No, I mean, like if you regulate the use case, if you regulate the use of the hammer, that's of course. So you argue any data and AI in relation to hitting someone in the head, needs is highly classified. So this is because it becomes really tricky, I think, when you can use it for anything.
But that's kind of closing the door after the horse has fled, right? You can only assess that after the fact.
There's a number of components here. They actually changed the AI Act quite drastically in just recent months.
Yeah.
They're actually moving to a more use case.
Yes,
okay.
This is where are we now on this journey?
It's probably because of our comments in the podcast, right?
No, but this is great. This is great.
I think
I don't know where
the
we are.
provider of a technique. Let's say we have Bosch building a hammer. A hammer can be used for a lot of things. It's general purpose in some sense. Then should the provider of a general purpose tool like a hammer be required to comply with a lot of regulation, or should it be the company or person that is using it that should comply with the regulation? It's more a question of that, I would argue.
Better phrase than I did.
But that's an enormous power imbalance. Where a lot of the knowledge resides in the company who built it, and the little
that's
end user.
The power imbalance for sure, but still.
But in terms of burden of compliance.
Yes. So, but that's a different question.
Okay.
But I do agree that's a big problem. But I think from a regulatory point of view, as Henrik said before, if you just want to do it because you want to have nice art for art purposes, for example, we had the generative art exhibit here before. If you use it for that purpose, why should you be required to have the same level of transparency and compliance as you do if you use it for, medical purposes or for warfare? I mean, that's not
because
right.
It can also be used to create child porn and pornography under the facade of.
Shouldn't that be punished and regulated then with the use case?
Is it possible for a legislator to find all the different use cases that would be necessary then?
Well, we have normal law for that. Why is this different than normal law in that sense? I mean, like, child pornography, is that legal? No. So anything that has a use case.
Should the camera provider for child pornography be?
So basically, are you going to fight? It's like going to Sony. You know what? You can use your cameras for child pornography, so you need to have that child pornography safe.
Yeah.
Can you fix that for me, please?
It's an interesting
how can Sony fix child pornography? I don't get it. I really don't get it.
I wonder if it has to do with the credibility of enforcement.
No, it's just dumb, because it's literally dumb, because if you take this back to any normal technology, what you are saying is that we should hold Sony responsible for child pornography. That's what you're saying. If you're regulating the technique. That is that you should hold any who makes camera lenses responsible, because that can turn into child pornography. That's absurd.
I think
and now it's just because it's a new technology we don't understand that we're really not rational in this.
But maybe a significant difference is that there isn't the capacity to surveil analog Sony cameras, whereas this here you can have certain characteristics by design that where you can regulate the process, right? You can allow for transparency or privacy in the process to get ahead of this problem, so that you're preventing child pornography from happening, rather than penalizing it once it has happened.
I think that's very nice stated.
Okay, that's an argument. I'm not sure I agree with it, because I don't know where this logic would go in the end, because then nothing can be done. Then everything has the potential of being, for anything. It's a general purpose technology.
What is the damage of making risk assessments and making it transparent?
No. It's very simple. You have used the argument leads to a very, very simple fact that any AI system is class 4. Period. Nothing is not class 4. That is what this is going to go to. There is not an AI system in the future that is not of the highest regulatory problem, because generative AI is going to be used for many, many different things. So ultimately, everything you do with algorithms will have the highest class of regulation. This is how I interpret it. if we think generative AI is mind-blowingly, paradigm shifting. So you have just now put a law that we need to treat everything from the highest standards. I give you an example. I worked at Vattenfall, and I was supposed to build data systems. And we have data systems for Ringhals, kärnkraft, nuclear power plants, and then we have systems for the rest of Vattenfall. And then I'm going to build an ERP system that works both for the normal people in Vattenfall and for nuclear. So if I went to Vattenfall and I then said, okay, I'm gonna make my security standards for every single person in Vattenfall as they worked in the class 4 zone in Ringhals, the cost of implementing that is insane. So what I had to do is I had to understand this is how we build ERP systems in general, and now I build a class 4 zone. This is way more expensive, made in a different way, and if I go the extreme, terminal server not connected to internet. And what is happening now, if you're not careful, you're going to put the whole world living by costs and regulations as we were running nuclear power plants across the board. Because generative AI potentially is going to be used everywhere. This is my rant. Sorry.
That is a terrifying future. This is dystopian science fiction, right? But
I think it could be a reality. But I think we also need to steelman this.
Okay, so now I put one argument in.
Yes.
So
and of course, I agree
flip
to
it.
what said to a large extent. But we should be also open with that the rules around building AI systems today is not properly set. I usually refer to Elon Musk. He compared it to. Elon Musk is very much for having better regulation when it comes to building AI systems, and he compared it to the car industry and the seat belts, saying, we had a lot of people building cars, and they were really afraid about the regulation that forced automotive manufacturers to have seatbelts because they thought it will drop the sales, and people didn't want to use seatbelts. So they fought with lobbyism and whatnot, everything they could to put this regulation into place. So it took like 10 years before they actually did put in the regulation, even though they had statistics for many years that seatbelts actually saved a lot of lives. And he said basically, well, he probably lost about 100,000 people or something that could have been saved if we had the regulation in place. But that's okay, he said. No, I'm paraphrasing a bit. But then he compared to AI systems. And let's say that we don't have a regulation for if you build autonomous weapons, for example. And they suddenly can be built at scale, having drones driving around, shooting people at that scale and very low cost. And we don't try to regulate this, it could be a severe problem. And that's where we're missing something today. But still, it's a use case of AI, but still we do not really have a good regulation similar to what car automotive manufacturers in that time had to comply with. So, and also the problem with AI is going so much faster than what the car automotive industry was.
Exactly, right? And I think this is also always a problem when it comes to legislation, that usually it's an afterthought. Something occurs and then something happens.
And that's exactly what he said. Usually it's a kind of big, catastrophe. There is an outcry. There is some kind of investigative kind of insight committee that look into it. But
what we're dealing with here, I would argue, is a bit different, because here there's the potential in the future. We can see that many things can happen. Yeah. Kind of anything could happen, but we still need to regulate that. So not only do we know where the puck will be going, but we will need to know like future states of where the puck will be going in order to regulate that. And I think that could be part of the delay in this regulation. And also, I think a year ago, this discussion would have been very different, because then ChatGPT didn't exist in the way it does today, and so on.
So this is more in mainstream. But let me open up. I think there's a huge pink elephant in the room. And that is, if you compare what happened when they invented a nuclear bomb, they realized, oh my God, we need to regulate this on a global basis. So the huge pink elephant, how the hell can we talk about this as a European regulation? Is it any value at all to talk about it? I don't think so, to be really frank. I really think we need proper regulation, but I think it needs to be global, and of course that doesn't exist. But for politicians to hide behind the fact that we don't have a department for that, screw that. That's what we need to fix. What do you think about that statement?
I think that's a fair observation, right? Like regulations are jurisdiction, country, European Union specific. But politicians can't protect people in other countries, right? They can't. The argument goes something like this: if people in those countries wanted them, they would protest on Sergels Torg, and so our hands are tied. That's the very pragmatic
dilemma, right? That's the real dilemma.
But then the other thing is, so there's also an argument that GDPR has created new norms, and so other countries have built their own data protection laws that are very, very close to GDPR, and that's both for normative reasons and also for pragmatic reasons, because they are tech hubs or back office tech hubs that work with European companies. So there's an economic incentive there as well to have de facto, if not in law, but very similar kinds of standards. I don't know how much more than that we can hope for.
But why? How did this happen? When we come back to how we quite fast put together treaties on how to treat nuclear.
But that was also a very different geopolitical time.
Yes.
With very different geopolitical powers.
Of course. What in what way? I realize, and I kind of understand it, but I don't know it.
So there was this mutually assured destruction, right? There was this, and it was. No, I'm not a history professor. My understanding, and you can correct me if you're wrong, if I'm wrong, and you know better. But my understanding is they got to the point where everybody had nuclear power, significant powers, and so there was mutually assured destruction. If we didn't agree to only use these for civil purposes, then something would happen, and we would, desolate an entire area of, I don't know, somewhere in the US, right? And there isn't this visceral threat. It's not as tangible. It's not as that's the one thing. But the other is that I'm not sure that all political powers today care so much either about what happens to other people's population or maybe even to their own. Right?
It's a very different climate.
It's a completely different and it's a lovely metaphor, but I don't think we would be able to. I have my doubts that we'd be able to, frame this as a mutually assured destruction and consequently get everybody to agree.
And I don't want to be the one preaching about social media, but I think it's actually a good example because we know that there are implications, depression, polarizations, etc.
We still use it.
And we still use it. And where is the global agreement in that? Because that's a global phenomenon, right? So I also agree that it's this is how we would want things to be, and why it's actually generally a good question. Why don't we always regulate important things globally, right? But
pragmatically, it seems impossible, maybe.
I mean, there is, what is it called? International, there's a name for it. But basically there are some kind of norms that are considered to be so internationally accepted that they amount to almost natural law, right? And you can take them to international courts and have them enforced. They're called international something.
Well, we're trying something similar with climate, of course.
Yeah.
The climate agreement. Yes. A climate agreement is maybe the closest we can see how this works on a global scale.
Yeah.
It exists.
Yeah.
We could have an AI agreement, like we have a climate agreement.
So the direction I thought you were actually going to go with social media was not we should ban social media, but that but given the ills of it, but what I actually thought you were going to argue was that coming to even in democratic countries, coming to some sort of agreement about very significant regulations like this requires consensus, and social media and disinformation in particular polarizes in a way that we didn't have under conditions of mutually assured destruction. And so Max Tegmark pointed to that Netflix documentary, Don't Look Up, right, where everybody's Twitter's redirecting. This is also a very real obstacle.
So the whole situation, the whole context, the whole climate is vastly different, complicating this.
Sure. Making it all the more important.
Making it all the more important if you flip it.
And the immediate threat of destruction is not really there in a tangible way, as in with nukes.
No.
But I think there's been a number of examples where we actually been successful in stopping or at least slowing down some development, like nuclear weapons, as you mentioned, but also like chemical weapons, just genomics. Cloning people has also been more or less. I think China has done it, but otherwise it's basically been stopped.
We had Dolly the sheep, and then it sort of died down.
Yeah, still not a human at least, but yeah. So there are examples, but I think we've been a bit negative about the regulation here, and perhaps lawyers in general. And I'd like to try to find another side to the positive aspects of it, since we are
the positive aspects of lawyers.
Yes,
there are lots of them.
That sounds bad. I don't know.
That was a bad setup. We haven't been negative to lawyers. I think that's really badly phrased, by the way. But I think this is super important topics, and they're super hard, and we're so grateful to talk to real experts on it, and because it's also a little bit like the rant. I went on a rant because I'm like, don't the regulator community see where this is going? Because if we follow, that's a rant, right? Yeah. And I'm not saying it's super important to regulate, but the way if you're doing it in a dumb way, it will not work.
But the problem is that there's this plurality of approaches, right? And all of them have upsides and downsides.
Yeah, true.
And so you're coming from a particular perspective.
Yes. Of course.
Which emphasizes certain things over others. And regulators can approach the same problem from a different way, and it's still defensible.
Yeah. But I think you can phrase it even more offensive, or not offensive, but in a more positive way. So what I'm trying to get at is if we use regulation, and I think ethical guidelines or norms in general, it can actually be of something very positive. And perhaps regulation doesn't necessarily need to lead to an hindrance of innovation. It can actually be potentially a catalyst in some way that actually supports new type of innovation that wouldn't happen otherwise by simply having this type of innovation. I think GDPR, if you look at it from a steel manning point of view, actually have led to a number of innovations that have created commercial opportunities for companies, and also something that has safeguarded privacy in a way that wouldn't happen otherwise. Do you agree with this? Do you think that if you phrase like a regulation or norms properly, it can actually be more of a catalyst in driving the development of AI specifically then in a direction that it wouldn't otherwise have done? It's a very leading question.
So I think there's an interesting, it's a kind of sub-piece of your question, which is about transparency and understanding why the algorithms work in the way that they do. And the parallel is patents, right? Where you register exactly how something works, and then you get exclusive rights to it for a certain amount of time, but then after that people can use it to learn from, right? And maybe the same can become true here, right? So there can be innovation at 2 points.
I would like to argue on the second part, you can learn from pattern, but I stop it from now.
In principle. But then innovation can happen at 2 points. The one is developing innovative systems to balance doing radical things with doing it in a responsible and privacy and integrity protecting way. So innovation can occur there, but then maybe there are also kind of second wave innovations where that are a consequence not just of the implementation of the rules, but also the transparency requirements in the rules, where people can then learn to do stuff on the basis of those.
And in addition to what Claire was saying, it could also lead to those who are not comfortable necessarily using AI for various purposes, because of this chilling effect that it could lead to whatever, so they refrain from actually engaging. Then if it becomes more safeguarded, if they can be more comfortable with that things will not go wrong, and it's a safe environment, then I think that would also engage more users.
And maybe have better understanding, right? Because it's not a black box.
Yeah, exactly, it's not a black box.
But I think there's to have a stable playing field where we understand what we can do and not do is usually a very good foundation for investment or capital. I take the example, people say it's impossible to invest in energy, you know. It has nothing to do with that the opportunity is not there. It has to do with the political volatility. So the regulatory framework, can we do nuclear, can we don't do nuclear? You know, it flips by every 4 years. So there no one, and the investments is 50-year investments. so the instability is not good for innovation or investment. So from that point of view, if we can stabilize the playing field and the norms, that's the foundation for commercial innovation.
But also, I think we can all agree that a society without regulation and norms would be horrible. I think no one agrees or wants to have a society without regulation, right?
And especially in these.
That's a very leading question to lawyers.
No, but I think so. No one is misunderstanding.
But I mean, we're also not legislators.
But as no one understands, so no one misunderstands me. With the going on a rant here, I think this is absolutely vital that we get this regulated and we get this structured. I'm just scared that we are doing it, that we are not smart how we do it.
We can be just as obvious as it is to have no regulation.
That's crazy.
It's just as obvious if we have the wrong regulation, it will be very hurtful for our society as well. So then you have, as a lawyer, a super important job to find the right balance and formulate these regulations properly.
Yeah, it's super hard.
So this is on you, Jannika.
Yeah.
I'm not a lawyer.
and lawyers don't really formulate legislation. Those are more like
That's
the political.
But lawyers who
so
work
vote for the correct.
But lawyers work in policy formation offices.
Yes, true, as well. And lawyers also interpret.
Yeah.
But it also then drives home a very, very important topic of how knowledgeable you need to be on both the technology matters as well as the how to think about the as you said, you put it really well. Now you Henrik, you have a good idea, but you're unbalanced. There's other objectives from another way. So there's so many. You need to have so much competence on so many layers in order to do this. Of course, this has been a team effort in the EU Act. But it's excruciatingly hard, I think.
It must be horribly hard.
Yeah.
And also it's a regulation, so it's a one-size-fits-all kind of thing again. Same applies to all countries. This is it, all AI systems.
But it's interesting, have you seen, UK has done a couple, they put their sort of framework in place now. Then, it's interesting, they go slightly different route. They are talking about they're putting it very explicitly, balanced innovation or pragmatic regulation. I mean,
minimizing regulation, actually.
Yeah, they're minimizing regulation, but not in any way I interpret it like they are throwing out the rule book, but it's the ideology or the entry point into how they wrote their document is slightly different or quite different, actually.
Can we move to another topic as well, and perhaps a bit more into your specialty as well, Claire? I'm thinking specifically about ChatGPT and open sourcing. And OpenAI is today, I would argue, very far away from being open. And perhaps that's a good purpose, though. Perhaps that is what ethical behavior should be. Perhaps they are actually being very responsible by not open sourcing ChatGPT. What do you think about this?
I'm so torn because on the one hand, they've done extensive experimentation in an open environment with no rules and benefited from openness in that sense, and then closed off GPT-4 to other people, right? To the code at least.
And the model and the data.
And yeah, exactly. It feels like cherry picking. That they want the benefits of open source and open access, but not the quid pro quo. And it's unclear what their motives are, right? Of course, they say that this is about ethics and about the misuse of previous models, and there is certainly an argument to be made there. Their majority shareholder is also Microsoft.
Yes.
So that's the other argument.
I think they wouldn't say the shareholder, it's investor, but
investor, fine.
That's right.
So I don't know. They want to have their cake and eat it.
Yes.
And
Well put.
And I guess I just don't know. I think that.
I mean, if we elaborate on the potential, there are pros and cons with everything. So the pros, of course, of open sourcing it would enable a lot of innovation, and it also would open up a lot of transparency, simply how it works, and allow people to examine and do research on, how the model works, which could open up for a lot more safety and privacy and a lot of positive things. The negative things, of course, is that people could also start to abuse the model in different ways and change the way it works, remove the safeguards they have put in place, and use it for propaganda purposes, disinformation or whatnot, and radicalization in social media, and so many more things. So then we can see also that obviously there are coming up more and more open sourced version of this now. They're popping up every week or every day, more or less powerful than OpenAI. What is really the proper way here? I mean, should we regulate about open sourcing? Is that the way forward?
I mean, there are rules that already exist in respect of open source proper, right? And it's the quid pro quo. I use your code, and then I release my code on the same terms, right? And it's complicated when you get code from lots of different licenses, and let's not go down that route. But it is built on this quid pro quo.
GPL kind of licenses.
Exactly, GPL is one of them. So that norm would say that, but at the same time, these guardrails are very important when we see that there is misuse going on. I really don't have an answer. I wish I did. Henrik used the word expert earlier, and before we were talking, I said I object to that because it implies that we have answers when
that's the humble type of expert. Proper way of phrasing it.
I go, dear goodness gracious, this is hard.
Jannika, do you have any thoughts? Should OpenAI have open source their model?
I'm not an expert on on open source, but what does come to mind is the automated decision making in, again, GDPR, including profiling, and how when you are for instance, when it comes to the transparency requirements, you do have the right to know if you have been subject to automated decision making, which includes providing the logic and the foreseen consequences and so on of what that could mean for you or regarding the processing.
But would open sourcing a model help with that?
Yeah, so that is the thing that I'm also debating, that probably not. And the way that this kind of logic is described is not,
So tough questions.
Very tough. Yeah.
What would you guys say?
Yeah.
Surely you can answer it.
Yeah, because you came up with the questions.
We are the
obviously.
Experts. No, we are not experts for sure. So I think it's a really hard question. I can certainly see the point. If you truly believe that Sam Altman and others do believe that the responsible thing to do is not to open source the model, I can see that point. Then is it also a commercial aspect of this? Of course. I mean, no question about that. But there can be a significant amounts of abuses if you put these kind of models into the public domain. But it already is. There already are alternatives. And my thinking a bit is here, some models like from Facebook or Meta, they put a license on it saying it's not for commercial use. Okay, good. It's only for research, perhaps. That means that the people that are good, the people that, and companies that are following the rules and the laws and the licenses, they will not benefit from this. The people that are abusing it, perhaps it could be some states, perhaps it could be terrorists, perhaps it could be organized crime or whatnot. Will they care about the license? No XX way, right? So who is this really helping? Is this a proper way to safeguard powerful tools? I don't think so. So it's a really hard question, but I think, if we simply could regulate this in a use case way, and then when someone abuses it, at least we have the regulatory framework and tooling to fight it and find them and reduce it. That I think would still be good. We don't have it.
But it's also a game of whack-a-mole. I mean, even if they use it for things that are already illegal, you still have to find them.
Yes.
And so maybe like we were talking about the AI Act and defining processes rather than consequences, right? This is the same thing. This is saying we're not letting this process occur because we're worried about the consequences. Even if there are good use cases for it to be open, we're so worried about the bad use cases that we're.
But I'm very much inclined to go down the route you were on to, Claire, with how we help people get it right, to do it as right as possible. Couple of reasons. Believing man is inherently good. There will always be bad, of course. That's why we need to regulate. But a lot of the problems we have is because we didn't know better. We did something we didn't know better. If we knew better, we would have done it differently. And in the most pragmatic sense, when the genie is out of the bag, so to speak, I don't think you can stop it. I think the bad people will work around it. It will find a way. Evolution will find a way. So then, how can we help evolution? And then I think you're down that track, supporting, supporting that we do it right by design. Yeah, regulation has to be there, and punishment like this. To answer the question on open source or not, impossible question to answer, because in the end, I think companies should be free to have their commercial model that suits them as well. I think there are different routes. What I have a real problem with is double standards, double morals. It's when you are conveying one message and you're doing the opposite. Please change your name. You're not OpenAI anymore. You're not a research institute. You started out with this and you're trying to have this aura, and you're not. You're a commercial company. That's my problem. But when they are not clear, I think that's the problem.
Yeah, well said. I agree. Time is flying away here, and I'm trying to choose a bit which of all the questions we haven't been able to touch that we should focus on. But I'm going to choose one a bit more philosophical. Let's start with a short one, and perhaps it's not short, but
you're not going to stop before 9:00 today, Anders, right?
Let's not go there then. We'll take another one. I think you knew which one I was planning to take, but let's not go there. If we take the singularity one, so okay, there are a number of different definitions of what AI is. It can be the narrow type of AI that we have today. It can play chess and drive a car really well, but then we have the general purpose and then AGI type of systems. that can work with any kind of system, and of course we're going in that direction for most systems, and that's cool, but also dangerous in many ways. If we take the singularity, that could be a point where potentially we lose control. So we don't anymore can say that we can't pull the plug. We can't say that we can't put the genie back in the bottle in some way. And just to give an example of that, we can be closer to that than people think. And especially it means that if we have a feedback loop where a system can self-improve, it can go really quickly. It can be a super simple system actually, just because it has a self-improving loop, it can actually improve very quickly. If we then say that we know that GPT-4 can code better than a lot of people, and then you say that we will have autonomous cars, yes, so we will speak to a car instead of driving a car. Perhaps we will encoding speak to a system instead of program a system in the future. What if a system starts to speak to itself? What if a system starts to say, please, I saw a problem here, but I have this goal. Now just reprogram myself. And I'm not speaking about an AI model here. It's really changing the code and adding whatever functionality I need to do whatever I want. That becomes, a system that has the human out of the loop, and it can start to self-improve. Is that something you're afraid of, concerned with? Do you think that will be a real danger anytime soon? Jannika?
This is where I regret not reading Singularity is Near, but I bought it, the book. Kurzweil, I think it's called. Who wrote it?
2029, I think. I think Singularity was further down the line. But anyway,
but there's, and doesn't he predict that?
2029 is one of the dates. He says.
And
I think that's
AGI.
Singularity will happen, I think, a bit potentially later, but still.
And so on. So I don't really have a qualified answer to your question.
I think no one does. So it's nowhere one.
But we can always speculate
yes.
Around it. I used to. My opinion used to be this. I spent my summers in my childhood in my grandparents' summer house, and they had an absolutely amazing collection of Donald Duck magazines. And I remember the uncanny feeling of reading about like flying cars. These are magazines from the 60s, by the way. And reading about in 2001 we will have flying cars. And just being like, that's ridiculous. And that's kind of been my approach to this whole general AI. AGI, yeah, exactly. And the singularity and so on. But lately, I don't know. I'm inclined to sort of change my opinion about that, and that it actually is not such an outrageous idea, because I think things have happened very fast. Just a few years.
We need more regulation in place now.
I'm not saying that necessarily, but I do think it needs to. Something needs to be done.
And I'm not laughing I was laughing, but still, I don't think it's unreasonable to think that actually it could happen soon, and that's why Elon Musk and Stephen Hawking and so many others are speaking out about this, and Max Tegmark. Yeah. Could happen.
It feels like some of the guys who are kind of in the know or have seen stuff is starting to more and more people are leaning into this goes quicker. And of course, Kurzweil's law of accelerating returns, highlighting that we have a hard time understanding how innovation accelerates. And we have a very hard time to understand exponentiality. So we're looking back 30 years to understand, where we will be in the next 30 years. And we don't consider exponentiality. And especially not when the real steepness of the curve starts to occur, how fast it is. And in some ways, I think that's what we're seeing. It's very simple, right? And obviously then, what looked like 500 years is 50 years very fast. We're talking logarithmic scales in the end, right? And increasing rate of accelerating returns. That's logarithmic. logarithmic is crazy in terms of exponentiality.
It might be related, but somehow not related. But what are your take on Moore's law nowadays?
It depends on which one you're speaking about. But if you're speaking about the number of transistors on the square unit of some
circuit,
place, then of course that's been flattening out recently. But the exponentiality of the amount of compute that it can get from an amount of energy or dollars or money, that is continue to increase, and it will so, I would say, for a long time. So the exponentiality is still there, just not in terms of number of transistors, I would say. Would you agree? Or?
Yeah, that sounds reasonable.
But first, we need to have your...
I mean, I think a follow-up, I of course have no idea when any of this will happen, and but a follow-up observation is if we are concerned about the rate of acceleration, if we are concerned that it is nearer than we think, then maybe we should also be concerned about what it is that these algorithms are being trained on, right? Because there is something that they are learning. I mean, there's this famous example, turning a chatbot into a kind of xenophobe and a Nazi more or less overnight. Like, there is an important question about input that doesn't get and bias and discrimination. On the one hand, bias and discrimination. But also there's a really interesting stream of research around how humans relate to algorithms and chat and robots and stuff like that, and consequently how we talk to them, right? If we talk to them politely, if we swear at them and treat them like, maybe these are also discussions that we should be having, right? It's not just is this going to happen, but if we take it that it is, if not a given, then something very likely, where do we point it? And that's really important.
But you said something now, because maybe a couple of years ago we were discussing of this as something so unlikely, so could it ever happen? Are we now talking about the likelihood that it will happen is quite high, it's more a matter of time? Have we changed opinions to it's a matter of time now? Because if I asked this, even if 3 years ago when we started this pod, I think we were talking more hypothetically.
Not me, but
not you, but no.
I always knew.
We have the singularity question for 3 years now, and I think there is a swift shift in the last half year on how we treat this as not an if question, but a when question.
I mean, for me, it doesn't. The question of what we train these algorithms on doesn't matter whether we approach singularity or not, right? There are much more proximate and immediate consequences of feeding it unbiased data, of teaching it to be racist and xenophobic, all of these kinds of things. So from my point, it holds irrespective.
Yes, I agree.
I don't know if there's been a change in the way people think. I think it depends on who you talk to.
Final question, because of time limits. It's so many others I wish we could have spoken about. But let's take a general final question, which is more in terms of, are you an optimist or pessimist in terms of AI being able to be of positive use or negative use in our society in coming 10 years? If we start with you, Jannika, are you an optimist that in coming years it will be of benevolent use for our society?
I would say I'm an optimist when it comes to most things in life. I'm worried about this, and I'm worried about climate change. I think much of what have already been said here holds true to that there are massive concerns that if we don't find a way to mitigate the risks, we will not be able to put the genie back in the bottle. That is my concern. I think there's a fantastic upside to what can be done, and I think that can be absolutely spoken about more, and the potential for just almost magical things and unimaginable benefits to society and so on. But we need to somehow find that direction, because now we don't have any direction, and that sort of usually doesn't tend to lead to a good path. Maybe eventually, but currently it's just there are so many.
We will find the path, right?
If we don't go extinct
if you
before.
were to bet, $10 against or for, it is still.
Eventually, I think everything will be fine if we don't go extinct before. So then it's just a matter of that's a big if.
If we don't
but
kill ourselves,
I will be
okay.
a optimist about this and say that the benefits are.
Claire, what do you think?
Yeah, it's interesting that you compare this to climate change, because the inability to make significant inroads in climate change bears reflecting on when we're thinking about this as well, right? I think there can be enormous upsides, particularly for us in positions of enormous privilege, as people who understand the technologies, who are in developed countries, all of these kinds of things. For us, probably, but maybe there is cause for concern, particularly in respect of who controls these technologies. So big
imbalance.
corporations, power
Power
imbalances.
AI divide topic.
But also the creation of new elites through this, right? Which usually happens with new technologies. That there's the good old boys and then there's the new good old boys, and these things these kind of socioeconomic consequences we need to be mindful of as well.
But you're more positive than negative, or?
I don't really know. I'm terrified of all of it altogether, particularly as someone who has children and all of it, like where is this? What is this? Why aren't people doing more, doing faster? And of course the answer to that is because we have to understand it first. But it sometimes feels like stasis, and it's the stasis that is terrifying more than the technologies itself.
Well put. Awesome. What's next in your life, Claire? What's happening privately, professionally? Anything happening coming weeks, months?
More awards.
Days?
No, yeah, there's the
award.
The award, yeah, right.
the Dalboy Award next week.
Next week?
Very exciting. I have 10 minutes to try and tell them all the things.
So how does that work? You're gonna do you have a small presentation?
Yeah, there's a meeting. So there are two people who got it. The one is me, and the other one is a researcher in finance at Stockholm University. And so we'll both present what we've done, and say thank you, and hopefully, I mean, I spend my life trying to find more interesting things, right? I mean, this is why one is a researcher, right? Is because this is very interesting, and this is very interesting, and there is an attention problem where you have to try and focus on something.
What is the thing that is grabbing your attention research-wise that you want to dig into?
I think this is part of it.
AI?
I think, but because of the collective action angle, right? Like the technology itself. You guys can do that.
No, but I think you nailed it, because we got there in the end, collective action dimension of.
But
AI.
also there's this really interesting thing. There's an American legal scholar called Jonathan Zittrain, and he talks about intellectual debt. And intellectual debt is so on he uses the metaphor of pharmaceuticals. On some drugs, on the little pamphlet, it says this works to do X, but we don't know why. We just know that it works. And most AI, the most complicated ones, are that, right? We know that it does X, but we don't know why. And given that we don't know why, how do we govern it? How do we make it ethical? How do we make it safe? How do we point it and shoot it at the right problem and know that it is at grasps that problem rather than some proxy for the problem, which is what it usually does, right? Like if you look at all of the bias and discrimination cases, that's the reason why. They're not actually screening for risk and identifying risk factors. They're finding some other proxy.
Similar to humans, right?
Yeah, except hopefully we're more reflective than that. And we notice
So
when we're
far,
doing it.
But perhaps not.
Anyway, so I think maybe that's part of what I'm doing. But then also I have this very interesting DAO stuff.
I wish we had time to speak more about that. Yeah. But okay, perhaps.
But this is an AI podcast. There are no DAOs here.
We can take that afterwards.
Yes.
Yeah.
Jannika,
Amazing.
what's happening next in your life?
Well, if no surprising awards will come around.
I give you the Amazing Jannika Award.
Thank you. We didn't really talk about it, but there is this initiative of Digital Decade from the European Union. I don't know if you're familiar with that, but there is a lot of legislation coming when it comes to the more digital sides of things, and promotion break. We will have some seminars regarding this if anybody is interested. From Knowit, yeah. So we'll be speaking there on the AI Act. Come and listen.
Nice. Nice. I will.
You should send a link or something.
And
Yes.
yeah, sure. I can definitely do that. So that's exciting. Just generally pondering how to deal with this new wave of how to make data protection even better, how to find the core of things, so we don't get stuck in the things that kind of needs to be in place, but that we can move onwards to what is actually important and to do that more efficiently. And thank you for all your input in that as well. And
awesome.
Future of being a lawyer. I don't know.
Awesome.
Yeah.
Great.
Think about your
Philosophical
private
things.
life as well, so have some fun as well.
Yeah, I will definitely.
Anyone, Jannika, that you would recommend to this podcast? Someone that you would like us to speak to?
Josephine Rosén.
Yes.
I think you should look her up if she hasn't been here. Ask her. Extremely interesting person. And a few years ago, I was at a conference in London and happened to sit next to Katie King during dinner, and she had a fantastic keynote speech there. She's a UK author speaker on AI. So
What was it? Katie
King, I think she's called.
Katie King.
Katie.
With K.
K ends with IE.
Yes.
Yeah. So one of those.
Claire, anyone that you would recommend to the podcast?
So we actually last time we were here, we had this art exhibition,
Right.
and there's a really interesting guy who I've sort of become friends with, who's both an artist and a data scientist, called Half Shidel. I think you should, because he's one of these unicorns of people who's super technically competent and also really interesting and interested, like kind of a polymath, one of these
Multi-talented people.
So I think he's really interesting. There's an amazing researcher of robotics at KTH, and my brain is not working to remember what her name is.
Nietzsche or something?
Yeah,
Of
exact.
course. Yeah.
Exactly. Exactly. And then
I'm not. We know her well. So yeah.
Okay.
Awesome. Yeah. Great suggestions. It's been 3 hours, far too long. We aimed for 2 hours, but and so many questions that we didn't have time to cover.
So awesome conversation.
But yeah, it certainly is a super interesting topic, and you can speak forever about this. But thank you so much.
I learned so much. Thank you very much.
Thanks for having us.
Thank you. We learned so much.
Yes, absolutely.
Oh, sorry, I did. I couldn't speak for Jannika. Jannika
you
knew all the
definitely
things
did.
already.
No, definitely not. It's been extremely interesting.
Thank
Thank
you
you
so
again,
much.
and
you
hope
very
you can
much.
stay on for some after work discussions as well.
Looking forward.
Thank you.
Thank you.
you.